if I may mention, 4 applications under Section 11, Lordship. Lordship, these are connected matters which can be heard analogously. The pleadings are complete. It's only for hearing. So if I
We'll hear it.
May I
No,
permit?
no precedence.
Lordship, it's from the non-commercial list. If I may,
And another matter is
come up.
there similar. It is item number
17
17.
already appearing in your Lordship's.
All right, we'll see 17.
May I permit?
Permitted this execution matter for withdrawal.
May I permit to mention one matter only? For leave to file the appeal without certified copy. Your Lordship directed me to communicate, requested the arbitrator to supply the certified copy. I request it was received, but till date they have not supplied
Pursue with the arbitrator.
Yes,
We can't
I
make it
wrote a letter, I wrote a letter. Kindly see the letter, they have received it.
Whatever it is, you pursue. I'm not concerned with your arbitrator.
He is not surprised. Interim order, against the interim order. He will proceed the matter,
Sir, whatsoever it is, pursue the arbitrator. If I start this practice of entertaining petitions without the certified copy, everybody will be coming here. Pursue with the arbitrator.
He is the Chennai, I am not.
Wherever he is. He's in Timbuktu or Chennai, it doesn't matter to me. You pursue with him. And I'm not concerned with the letters which
they have not supplied anything, any notice, any unilateral appointment, they have not served any notice. Only respondent, communicate this order, Otherwise, I wrote a letter to the arbitrator with a request to supply the certified copy to challenge the same, They have not supplied it,
When did you write the letter?
Yes, this is the.
When did you write the letter?
19th, I sent 16th. They received in 19th till 2 days, 1st April,
Right again.
May I have your Lordship's leave to mention a matter? I am mentioning upon notice. Your Lordship was pleased to dispose of 2 applications filed by us to withdraw the security amount furnished by a 34 applicant. That the direction was passed on 11th of March with the direction that the amount should be released by the register original side within 10 days. However, it fell from the parties that the money has to be released by the Steel Authority of India. We have mentioned before the judge having determination, and an order was passed to release the amount within 10 days by Steel Authority on 18th. Today is on 1st. They have not yet complied with the directions passed by this Honorable Court. Let this matter appear before your Lordship under the...
Before the concerned judge where you have mentioned the matter. Where have you mentioned the matter?
As your Lordship was not there, in the meantime, the urgent determination with Justice Ravi Krishan Kapoor.
So he has passed an order?
He has passed an order saying that your Lordship was directed the register original side to release that amount.
Right.
Thereafter, we have mentioned the matter. We got it mentioned that only direction was changed that in place of the register original side, the Steel Authority of India, who was having the FDR, will release the amount. Right. And the Steel Authority of India has not at all complied with the order passed by.
File contempt. We'll see that. File a contempt application.
My Lord, may I be matter appear before your Lordship to be mentioned so that...
To be mentioned, I'm not going to pass an order. File an application, an appropriate application. File a contempt application.
Great.
My Lord, may I be permitted to mention execution application? My Lord had asked me to come back once my Lord returns from the circuit bench. My Lord, the arbitral award was passed in 2024. My Lord, is running in my Lord's monthly list. I'm seeking an upgradation. The difficulty is, my Lord, I'm an MSME. I am 24.
Whatever, I'm not doing any upgradation right now. If I
my Lord, the difficulty is, I'm an MSME, my Lord.
Wait for some time.
Lordship, may I be permitted to mention 2 matters which are to be withdrawn since the dispute arising out of the agreements are already been settled. Much obliged, Lordship. Lordship, this execution matter has been settled between the parties. I am praying for withdrawal, Lordship. And interim orders any vacated.
You have to give me otherwise it's very difficult to understand, because most of the stuff is not here. And it doesn't work on your hand. Can you have to work with it? That's Yes. Take down. Learned counsel, the petitioner seeks to withdraw the present petition since the matter has been amicably settled between the parties. Full stop. Copy of the instruction received from the client is taken on record. Copy of the instruction to withdraw the petition from her client is taken on record. The present petition is dismissed as
For the petitioner, Your Lordship, this is my execution application. I had mentioned this matter yesterday, Your Lordship. Your Lordship has indicated yesterday the correct approach, Your Lordship. The correct approach. The last moment of mentioning, Your Lordship.
Why are you mentioning at the last minute?
My apologies,
My
Your
lord,
Lordship.
I appear
Wrong
on behalf of
approach.
the, my lord, what debtor.
Yes.
My lord, your lordship will recall, my lord, yesterday, my lord, we had made that application for restoration of the
Yes.
section 34 application.
Yes.
So, my lord, I know I don't have much scope of objecting to the extension. I was only praying this. My lord, if you are considering that we have taken steps with regard to the section 34 being heard, if the
Separate thing.
extension can be done for a limited period, my lord. My lord, they have been taking it for 2 months, 1.5 months.
That
at
Your
this rate.
Lordship would
Your
decide, Your
lordship,
Lordship.
kindly limit the extension period for 2 weeks or my lord.
You have
3
nothing to
weeks
say
and
on
the
that, Your Lordship.
matter is made returnable on the 22nd.
The last extension was on 22nd January 2026, Your Lordship.
Sir, I am appearing for bank. There was direction on bank to release certain fund in favor of award holder. So, there was direction on us to submit affidavit of compliance also. So, I'm submitting.
Which bank you're appearing for?
Axis Bank, my lord.
Worship, I am appearing here with State Bank of India. We already filed the compliance.
Well, our case in the section 34 would be that they are not entitled to, but anyway.
My
if you
learned
read it-
friend will not submit on section 34 today.
No, I will not. I will not, but then already compliance have already been done.
Interim order was granted on 25th
Inter-
November.
Yes.
22nd of July 2025.
Twenty-second July or it is 28th November, madam?
22nd of July 2025. Justice Shorkar has passed this order, Your Lordship. Do I hand over this order, Your Lordship?
All right. You should have moved an application rather than mentioning it. What is this practice? Why didn't you move an application for
I'm
extension?
apologizing, Your Lordship. This I will,
Why should I pass an order on mentioning?
Your Lordship,
why should the
consider
interim order
this
be
for the
extended on
last time, Your Lordship. I had kept this in my mind.
Why
Your
didn't you
Lordship.
file an application? Why a GA has not been filed for extension?
Your Lordship, this is the practice, Your Lordship. I am apologizing on
The practice.
Your Lordship. Kindly. This is the last time, Your Lordship. This is the last time, Your
Order
Lordship.
needs to be
would
passed. Sorry, no order needs to be passed. The petitioner prays for extension of the interim order.
Your Lordship.
The no application has been filed for extension of the interim order.
Your Lordship.
Same cannot be granted on an oral mentioning. No order needs to be
Your
passed.
Lordship, on the last
File
occasion,
an application.
also it was not done, Your Lordship. Your Lordship, this is the last time.
Fine, and I'm no matter. File an application. Sorry, I will change the practice. Don't worry.
Your Lordship,
I have sub-
I will change the practice.
Your Lordship.
But I have
Your
submitted
Yes.
the complaint.
Sir, Your Lordship,
Sorry, madam.
file, Your Lordship.
Sorry, we'll change the practice.
Your Lordship then kindly gives us liberty to file an application. Your Lordship.
You always have the liberty to file an application. Nobody is stopping you. The compliance affidavit filed on behalf of the Axis Bank is placed on record.
Your Lordship, till then interim protection for a week, Your Lordship, for a week.
Nothing.
Then I'll come back with an application.
Don't get up at the last minute. Learn.
Interim.
Sorry, nothing doing.
Extension, my lord.
Your
Move
Lordship,
an application.
for a week, Your Lordship.
Move an application. We'll see that. Yes.
My lord, I tender my unconditional apology, my lord. This matter was fixed with consent of parties, my lord. Mr. Banerjee is not well, my lord. He could.
That's
Mr. Shatru, well, yes.
But I am well, my lord. My lord, can we, my lord, file our opposition?
Reply to
There's an issue with.
reply. And reply, my.
Lord,
that-
kindly-
29A application.
Yes, my lord. I'll reply to the other.
You're opposing because, my lord, when it comes up, my lord, then can be heard, my lord.
My lord, kindly take, my lord, the reply
Affidavit in opposition
and reply.
filed by the respondent is taken on record. A reply to the affidavit in opposition filed by the petitioner is also taken on record.
No, my lord, I have filed my reply, my lord.
That's what I'm saying.
Yes. Oh,
Taken on record.
I apologize, my lord, I overheard something.
At the request of the parties, let this matter be listed for hearing on.
My lord, on his request, my lord, it's being, my lord.
On request of the learned counsel of the petitioner, let this matter be listed on
My lord, kindly keep it next.
next week or
From
next week.
10th, I'm not there, my lord. Well, after that, or my lord.
5th of May.
Fifth of May.
You have one more matter on 5th or 6th. 6th you have. 6th will keep it on 6th.
6th.
6th. 6th of May.
Great. Great.
My lord, I'll seek your, my lord,
Yes.
my lord, for an adjournment, my lord. Mr. Banerjee is appearing in this matter, my lord. Next, kindly keeps it next week, my lord.
Any objection?
I am for the respondent, Your Lordship.
Any objection?
Your Lordship, my senior will come and submit.
My lord, they said that they
He's-
haven't.
So your senior was.
My lord,
supposed to
Your Lordship,
commence-
he is in code number 37. Matter is
He was
going
in
on, Your Lordship.
36. No, not 30.
In that case, I am praying for short passover, Your Lordship.
At the request, learned counsel of the petitioner states that the main arguing counsel is in some personal difficulty. Let this matter be adjourned to, when do you want?
yes, next week, my lord.
Next week. Keep it on. 8th of April.
Grateful.
I appear on behalf of the.
Your Lordship, I apologize. Yesterday, accommodation had to be sought for me. I was stuck
Yes.
in court 33. Your Lordship, this matter is basically the question which revolves why there is a, now this is coming up after affidavits. The only objection is that whether the section 21 notice, whether they got delivery or did not get delivery or not. That is the only question. Now, what we have submitted before the court is that we have posted it. Correct address, we have posted it. We had posted it to two addresses. One was their Calcutta address, one was the other address, the divisional office in Vijayawada somewhere. So now my submission was that the judgments all on NI Act and everything else is that whether if the track, because the lawyer did not take out the track reports or lost it. I don't want to get into that. That is a triable issue. That entire thing is a triable issue. Whether that is correct or not, and whether there is they have taken up the point of limitation. Now, whether the question of limitation will be, how will be adjudicated also. There is a decision here of High Court here also, which unfortunately lost, that prima facie also will not do. An ex facie conclusion has to be reached by the court in a section 11 application to look into the question of limitation. So my submission to this court right now was that your lordship will appoint an arbitrator, because it's a tribal issue, also may be taken up as a preliminary issue, because evidence has to be laid on it. What documents I have submitted, I have written letters to the GPO. GPO is saying that I don't have records. I will ask the chain of events which followed. And that is why it has taken such a long time also. This matter has been in the list for some time. So my submission only was, I have the judgments if your lordship wants to see, that it's a tribe, at the end of the day, it's a tribal issue. It is not a case of an ex facie question of limitation that it is barred. And also the question of limitation otherwise, also whether something has been served or not, is a mixed question of law and fact. It has to be gone into by an arbitrator after evidence has been laid on that. On that basis, my submission was your lordship will appoint an arbitrator. That is my sum and substance of my submission. If my learned friend disagrees, then I'll show the judgments. Otherwise,
He is not agreeing to the proposition which you have advanced.
Malad,
I'm saying he's not agreeing. Says,
Malad, my objection is twofold.
yes.
First is this section 11.6 application is not maintainable at this present form, Malad. And the second is the claim is deadwood claim.
Claim is?
Deadwood claim. It has to be knocked down at the threshold.
Yes, tell me.
Malad, if your lordship kindly consider
the opposition.
their petition, where they have shown the arbitration clause. If I am not wrong, Malad, at page 32. It's a type page at 33. This is an arbitration clause. The approved agreed mechanism is this. Whenever dispute arose, you have to first approach to the assistant engineer, thereafter the DM, then chairman. If it remains unresolved, you may refer the dispute to the arbitrator. But that's the section 20, clause 26. Before that, if your lordship kindly consider the assistant engineer part, it is clause 15 at page 29.
What is the 15?
Clause 15.
Clause 50.
Clause 15, one side, page 29. Decision of engineer in case of any dispute. My submission before your lordship that the dispute is not arbitrable, because our last payment was made in the month of June 2019. Thereafter, no invoice was raised for payment. Even if we discard the period of COVID, my lord, at that period of time, Lord, already 3 months, if it is rightly calculated by me, my lord, 3 months, 7 months, I'm sorry, 3 years, 7 months, 20 days has been lost. Past month. My lord, as on date, my lord, the date of commencement of the arbitration has yet to be decided, because 21 was not received by us. They have issued, but not sent to us. We have not received the language of the section is this, the section 21 notice has to be received by the respondent. And they have failed to prove before the predecessor of your lordships in this determination that 21 notice has been served upon us. And if your lordship kindly consider the 6th February 2025 order, my lord, whenever the extensive argument was advanced by both the parties, And whenever the question put to my learned friend on the other side, my lord, he took adjournment. And I kindly see the 6th February, if I am not wrong, my lord. Already copy can I say?
Yes, I'm seeing it.
Took
What of
adjournment.
service of the notice? Yes.
As on today, with affidavit, without affidavit, no proof of service. It has not been sent. If your lordship kindly consider the page 72 once. Of your lordship's brief. It's a legal notice, section 21 notice, alleged notice. If I take it as it is, my lord, in the annexure, it is dated 30th June 2022. And it is unsigned letter that has been annexed. And no proof of service. And unless, my lord, it is received by us, how the commencement of the arbitration will be decided. And the Supreme Court advised, my lord, the opined in the judgment, my lord, if I am not wrong, my lord, this is a judgment of Arif Azim, 2024 Supreme Court, my lord.
Give it.
I prepared a compilation of judgments. It is little bulky, my lord. All the judgments. The pagination has been marked. I mean, copy to nahi. I তোমাকে citation টা দিচ্ছি।
বলো।
Arif Azim, আচ্ছা। 2024 5 SCC 313. My lord, your lordship will get it at page 315. It's a running page, my lord.
Yeah,
314. And I am relying on paragraph 92. In the present facts and circumstances, well, the similar facts and circumstances in the Arif Azim, and Supreme Court opined that the two-pronged test has to be applied. Page paragraph 92 and running page, my lord, 358 of the compilation. Internal page at 357, 357, page 92, paragraph 92. If I may read.
Yes.
Thus, from an exhaustive analysis of the position of law on the issues, we are of the view that while considering the issue of limitation in relation to a petition under section 11(6) of the Act, the court should satisfy themselves on two aspects of employing a two-pronged test. First, whether the petition under section 11(6) of the Act is barred by limitation, and secondly, whether the claims sought to be attributed are ex facie dead claims and are thus barred by limitation on the date of commencement of the arbitration. My lord, first, the date of commencement of the arbitration proceedings has to be decided. Then the question of barred claim. Our humble submissions, we are on oath before your lordships that the date is absolutely a barred date, barred claim. And after Vidya Dorlia, my lord, it has been decided by the Supreme Court, if it is a day-due claim, it has to be knocked down. My lord, our submission is this: we have paid them last in the month of June 2019. Thereafter, no invoice. Contract was stopped by our principal contractor, Well. There was no scope for raising further any invoices for payment, and no claim raised thereafter. Only the idle charges, operational employees' salary, security deposit, these things, this thing, 1,72 lakhs. These are the demand, we have repudiated the demands.
When?
Go before the arbitrator, he'll decide whether the demands are legitimate or
Malat,
not.
kindly decide the date of commencement of the arbitration.
How will that?
Date of commencement of the arbitration?
Yes. From the date of commencement of the arbitration, limitation clock will start for the purpose of 11/6.
You tell me what is the date of arbitration which you are trying to show. I'm not understanding your argument, sir.
Lordship.
I'm not following your argument at all.
Lord, I
I'm
am
not understanding you.
Lord, if I may try again, my lord.
Yes, please try.
May I, the argument which has been raised, and that is what has been argued before also, your lordship, is that they have paid last in 2019 sometime,
Right.
even after taking the COVID period. After that, when we filed, they are saying the commencement is on the date the section 11 was filed. The reason for not arguing that they have not received or not received the section 21 notice is that section 21 notice was given in way back in 2022. If that is taken that we have received, then the commencement starts then, and then there's no question of to stop the limitation. Now, if they say that we have not received, they have not received, that stage, what will happen is, then they say, because it is in 2025 that you have January you have filed, it is time barred. They are taking that period. That is what, that is their basic argument.
That is so far
Your
as claim
lordship,
is concerned.
But your lordship, the main thing is there are various aspects of claims.
Lord, kindly
Also,
allow me to try once again.
Yes.
no, I'm just one thing, your lordship. There are
Get an
various issues
opportunity, let him
regarding
finish
the
it.
address also. One, if they, I will show in 2022, it was sent also to an address from where they all used to operate. But they had closed that up, though that was the official address of communication, that was closed. And so obviously it returned.
If it has not been served, not been served.
No, your lordship.
Yes.
My only instinct
You
is,
show me from your document it has been served.
no,
Let-
your lordship, may I just, I cannot show that.
Then it's not
No,
been served.
no, I'm that is what exactly I'm saying, your lordship. Under the General Clauses Act, read with the judgments, if I have posted it, presumption is that it has been sent. The presumption it has been sent. That is why, your lordship, I said that all of this will come in evidence, and that has to be done by upon evidence. And the question of limitation is ex facie. It is not just by saying deadwood. And that judgment, Calcutta High Court's judgment in Chandan Chatterjee versus Geeta Harihara.
What judgment you are talking about, sir?
Your lordship, may I just show you that?
Well, in the meantime, may I pursue once again? Well, it is absolutely correct, my lord. They did not disclose any proof of service. They have admitted it just now. And we have also not received the 21 notice. So date of commencement of the arbitral tribunal is yet to be decided. It cannot be decided without the service of 21.
You solve them again. You start your proceedings again.
That will be excessive barred, your lordship. No, your lordship, may I?
They also it's barred.
No, your lordship. May I just indicate? Your lordship will let me at least proceed the judgment.
Judgment gulo aage dilen na keন?
Your lordship will see the first judgment. Please give it to me. 2008, 8 SCC 529.
Give a copy to him.
Just 2008.
Give a copy.
8 SCC, your lordship, I am
Not today.
Reported judgment, my lord.
Always bring a copy for the other side.
very well, lordship. Your lordship will take it up on Monday or Tuesday, whichever. Tuesday maybe. Tuesday. I'll get that copies.
Oh, wait a minute. Monday.
Your lordship, Monday I might reach
Wednesday.
late. Monday I might reach late. to court.
Wednesday.
Wednesday. Very good.
And please come prepared with the 2-pager so that we know exactly what you're talking.
I'll do that.
I shall also hand over the copy of it to compile it.
Very good.
Don't worry. Sir.
My lord, I beg to appear for the petition, my lord.
My lord.
My lord,
AC चलवाओ AC
my lord,
गोपाल AC ऑन करवाओ दूसरा कंट्रोल ना 26-27 में चलाते हो तुम लोग पता नहीं किस खुशी में Yes.
my lord, this is an application under section 11, my lord. The petitioner, cooperative society, my lord, enter into a commercial contract with the respondent number 1 and 2, my lord. Thereafter, my lord, certain dispute arises, my lord, and my lord, the arbitration clause was invoked, my lord. My lord, they failed to comply with the agreed procedure for appointment of arbitrator, my lord. My lord, hence this application was made after, my lord, invoking section 21, my lord. If your lordship, if I may invite your lordship,
I have taken the point of maintainability because
my lord,
Cooperative Societies Act provide everything. Arbitration
My
Act
lord-
will not apply. That's the point I have taken.
the sole argument they are putting forth is the point of maintainability, my lord.
Yes.
I would try to apprise your lordship that, my lord, that law has been settled by the Honorable Apex Court, my lord. My lord, if your lordship kindly takes page number 34, my lord. My lord, paragraph number 3, my lord, if I may read it out, the owner and the developers hereby agree to abide by all. It is from the middle of part, my lord. If any dispute arises to the effect of the parties hereto shall be settling by any arbitrator or arbitrators appointed by the parties by their mutual consent, my lord. My lord, when we invoke the section 21, my lord, they did not tender their consent. Thereafter, my lord, after execution of this particular agreement, my lord, a tripartite agreement was executed. This agreement, my lord, was executed between the petitioner and the respondent number 1. Subsequently, my lord, what number, please? If I may invite your lordships,
Society has a method of resolving it. Can you go before the society?
my lord,
Law says so.
my lord, I'll apprise, my lord. To that effect, my lord, I have already prepared a short notes of argument, my lord. If I may,
Doesn't look very short.
no, my lord, the judgments are voluminous, my lord. The note itself is very short, my lord. If I may file it, my lord.
Supposed to tell me from the
My
facts.
lord. My lord, after the execution of the first agreement, my lord, the respondent number 2 was inducted as an investor by a tripartite agreement which will appear at page number 55, my lord. Whereby, my lord,
Wait a
the-
minute. What are you? You're a
I
contractor.
am, my lord, I am the developer, my lord.
You are the developer.
I am the developer.
What are you developing?
My lord, a building complex, my lord,
Under
consisting of residential unit as well as commercial units, my
your
lord.
contract is with whom?
Contract with, my lord, the respondent number 1 primarily.
Who's respondent number 1?
Respondent number 1, landowner, my lord. The
landowner.
landowner, original landowner.
All right.
My lord, thereafter, respondent number 2 was inducted as an investor as there was a shortage of fund.
All right.
Thereafter, my lord, the profit sharing was defined, my lord, in the tripartite agreement. Subsequently, respondent number 2 exited, my lord. Then, my lord, a power of attorney come, my lord, a subsequent agreement was further been executed, which will appear at page number 58, my lord.
Whether the regulation of the society comes
My
into
lord,
picture.
I'll now place those, my lord. My lord, their sole objection was regarding section 102. Actually, sir. Section 102.
102 and 103.
If I may read it out, my lord. একটা বই দাও। My lord,
You are a society.
my lord, I am a society, my lord.
You are a society.
Admittedly, I am a society. My
Yes.
lord, admittedly, I am a society. Admittedly, there is a commercial contract between my society and the respondent number 1 and 2, those are not in dispute, my lord. My lord, chapter 11, section 102 and 103 specifically deals with, my lord, the dispute resolve mechanism, my lord. But my lord, my respectful submission is, my lord, this mechanism pertains to internal dispute, any dispute arising within the cooperative society, not that between a cooperative society and a alien and some third party, my lord. My lord, to that effect, my lord, that's why I was handing up my brief notes, which contains two very important judgment, my lord. One, if I may, my lord.
102,
If I may, my lord. আমাদের copy
Lord,
লাগাও।
C.
My lord,
C and D covers.
if your lordship,
Respondent number 2 is also, my lord, another society, and their members.
my lord, similar issue arose before Rajasthan High Court, my lord. Rajasthan High Court dismissed, my lord.
This is intercept between the society, sir. This is not regarding any development
My
agreement.
lord, I bow down. Lord.
This-
My lord, may I just clarify?
My lord, if your
But
lordship
that's
kindly
the
take
judgment.
my page 15, my lord, internal page 257 of the first judgment, my lord. 15, 1-5, my lord. 1-5 of my written notes, my lord. 15, internal page 257. My lord, this is, my lord, has been reported in 2021, 17 SCC 248, my lord. Relevant pages, my lord. Primarily, my lord, 257, my lord. Internal page.
Yes.
My lord, if I may read it out, 6.3. It is further submitted that even otherwise considering section 58 of the Rajasthan Cooperative Societies Act 2001, my lord, this section 58 corresponds to 102 of West Bengal Societies Act, my lord. The dispute between the parties was required to be resolved by the register, and the decision of the register shall be final. It is submitted that non-obstanted clause as contained in section 58 of the Rajasthan Cooperative Societies Act 2001 supersedes subsection 5 of section 12 of the Amendment Act 2015, and therefore no court of law shall have jurisdiction to entertain any suit or proceeding in respect of such dispute. My lord, it is identical to their claim, my lord. My lord, thereafter, my lord, I would not trouble your lordship much. If your lordship kindly takes up page 21 and internal page 26, 263, my lord, where, my lord, the Supreme Court settled the law. If I may read it out, my lord. Paragraph number 13. Now, so far as the submission on behalf of the petitioners that in view of section 58 of the Rajasthan Cooperative Societies Act, the dispute between the parties is to be resolved by the register only, and per bylaws 30 of the Rajasthan Cooperative Societies Act 2001 shall be applicable, and therefore no court shall have jurisdiction, and therefore the dispute referred to the former district judge is unsustainable, is concerned, has no substance, is cannot be disputed that the Arbitration Act is a special act. Even subsection 5, my lord, subsection 5 of section 12 also states that with non-obstanted clause in the distributorship agreement, my lord, ours is development agreement, dated such and such, there is a provision to resolve dispute through arbitration, just like in our case, my lord. Despite section 58 of the Rajasthan Cooperative Societies Act, there is an agreement between the parties to resolve the dispute through arbitrator chairman. Parties are bound by the agreement, and neither section 58 of Rajasthan Cooperative Societies Act shall not be applicable at all, not the same shall come in any way of appointing the arbitrator under Arbitration Act. My lord, this judgment, my lord, was followed. Thereafter, my lord, following this judgment, page, Honorable High Court of Karnataka, my lord, decided an identical matter, my lord. Decided an identical matter if your lordship kindly takes page 31, my lord. If I may read it out, my lord.
31
Para
of-
4,
31 of what?
31 of আমাদের notes.
No, you have
No.
not given me the notes.
My lord,
immediately.
notes are not generally exchanged, my
How
lord.
can you follow your
My lord,
31 page?
we have already
You have given the judgment.
we have already sent them judgment.
No, one judgment they have
Two,
referred.
two judgments has two judgments we
No.
have already served them.
They have referred, my lord. They have referred one judgment.
Two judgment, my lord.
That is clarified. That I will
Are
place.
print out আছে?
So far as other they are saying, my lord.
No,
No,
Forget
it-
about the notes. We are not seeing the notes. You see the judgments.
My lord, I am handing over another judgment to my learned senior friend.
Very well.
My lord, similar matter, rather I stand corrected, identical matter. Para 4. Notice have been issued by this court, the respondent entered appearance. The contention taken by the respondent is that the petitioner, being a cooperative society, no arbitration proceeding could be initiated and any dispute would have to be referred to the disciplinary authority under section 70 of the Karnataka Cooperative Societies Act. My lord, there they took the plea under Karnataka Societies Act, Cooperative Societies Act. The learned counsel for the petitioner, by relying on the decision of the Honorable Apex Court reported in AIR 2021 Supreme Court 4869, had contended that the Arbitration and Conciliation Act, being a special enactment where the agreement were to be governed by an arbitration clause, then the statutory dispute resolution under section 70 of the Karnataka Cooperative Societies Act would not be applicable. In view of the matter, the Honorable Apex Court held that section 58 of Rajasthan Cooperative Societies Act is in line with 70 of Karnataka Cooperative Society Act, and my lord is in line with our 102. My lord, thereafter that relevant paragraph was set out, my lord. My lord, thereafter the most relevant portion of the judgment, the Honorable Apex Court having categorically held that if an arbitration clause were to exist in an agreement between the parties, the dispute were required to be adjudicated by way of arbitration, then the statutory requirement under the Cooperative Societies Act would not apply. As such, the contention of the learned counsel for the respondent would stand rebutted. Order, my lord. The petition was allowed, my lord. My lord, the third and final judgment which we have relied, my lord, is Withdrawal, which is well known to your lordship, my lord, where it has been stated that on the principle of competence, the arbitral tribunal has the jurisdiction to try any of the points, even regarding maintainability, my lord. And it has also been held in Withdrawal that the court exercising jurisdiction under section 11 has very limited authority. It will assess whether there exists an arbitration clause or not, and whether if that arbitration clause is valid, then a court under section 11 will send it to the arbitral tribunal for further adjudication, my lord. My lord. Yes. Therefore, my lord, my respectful submission before your lordship that, my lord, the law has well been settled, my lord. The point of maintainability urged by my learned senior friend, my lord, impugn no merit, my lord, hold no merit, my lord, and my lord, this petition should be allowed while dismissing their contention, my lord.
My lord, we have lots of indulgence, my lord, to clarify this. Now, my lord, the writ petition kindly come, my lord, paragraph 2 and 3 about their status. What they have admitted, my lord.
My lord, if I may, in the meantime, file the reply, my lord. The reply was not been filed.
Paragraph 2, my lord, the petitioner is number 1, Cooperative Society, registered under Society Cooperative Societies Act. Para 2, lordship. So admittedly, it is similar cooperative society. registered under West Bengal Societies Cooperative Society Act. 3. Respondent 1, Director of Dakhin Dinajpur District Central Cooperative Bank, along with people of such and such, such and such. So it is fight between two cooperative society. Now, my lord, what the merit is, I will not trouble your lordship at this stage, because there are allegations, lot of allegations, 4 crores, they have taken loan, a lot of things. I am not just divulging all this. Therefore, my lord, admittedly, they are saying this is fight between two cooperative bodies. Now, lordship, kindly come to the act itself. Hundred two. My lord, speaks about who will avail the opportunity of this, my lord, provisions of law. My lord, any dispute, 102, has your lordship got it? Concerning the management or business or affairs of a cooperative society other than the dispute relating to election in a cooperative society as and when such election is conducted by the Cooperative Election Commission, and disciplinary action taken with the cooperative society against the paid employees regarding the terms and conditions of the service shall be filed before the register. So 2 things are, my lord, excluded. 1 is, my lord, election, related to election and disciplinary proceeding. Other than these 2, all other affairs can be adjudicated. How, my lord? A. Amongst members, past members, persons claiming, I am not on that. B. Between members, past members, I am not on that. C. Between the cooperative society or its board and any past board, any officer, agent, employees, any past officer, past agent, past employees, or the nominee heirs, legal representative of any deceased officer, so and so. D. Between the 2 cooperative society, this is relevant for this purpose, or between a cooperative society and a liquidator of any other cooperative society, between liquidator of 2 different cooperative societies, and between cooperative societies and any person, so and so. So, my lord, this comes, their status is covered by, my lord, D. Both the parties. 2. Any dispute mentioned in 1. 1 covers, my lord, any administrative, business affairs, management, whatever it is. So, dispute is covered. There any dispute mentioned in subsection 1, other than a dispute relating to recovery of money, shall be filed before the registrar within 3 months. So, my lord, here law says that dispute should come up before the registrar within 3 months, except money claim. That's, my lord, some more time is given. They have not approached within that period of time, so they have lost it. So, alternative remedy they are thinking about, and they have filed this, my lord, petition. Be that as it may, then, my lord, kindly come to 3. Notwithstanding anything contained in this section or any other law for the time being in force, the registrar may admit and dispute either expiry of this period of the limitation. After the expiry of the limitation, it can be admitted also, subject to, my lord, satisfactory grounds are made available. Then, my lord, 103. The state government shall constitute a board of arbitrators consisting of a chief arbitrator of a rank of arbitrators, registered cooperative societies, and 10 other arbitrators, 5 from amongst the officers of the Department of Cooperation of the government, and 5 from amongst the distinguished corporators of the state. A dispute under 102 relating to all apex cooperative societies and all federal cooperative societies shall be filed before the registrar, shall, after condoning the delay, so and so. My lord, 3. A dispute relating to the cooperative society other than those mentioned in 2 shall be filed before officers authorized to exercise the power of registrar. This is coming under 3, lordship. This 3, subsection 3. 103, 3. And decide the dispute himself as an arbitrator, and appoint 1 arbitrator and 4 arbitrators for disposal of the dispute. The register of the arbitrators of the board of arbitrators or the forum arbitrators, as the case may be, may, on the application of any party to a dispute referred under section 2 and 3, and of such terms as he and it can think fit, make, after giving the parties an opportunity of being heard. 5. A dispute filed before the registrar under section 2 and before the other authorized to exercise the power of the registrar under section 3 shall be decided within 6 months. And B. If the dispute is not decided within such and such, such and such. Therefore, thing is this, my lord, arbitration, my lord, mechanism is available there, and this is absolutely, my lord, fight between the 2 parties which are covered under 102. And, my lord,
how is it covered between under 102, sir?
Pardon, please, lordship.
How is it covered under 102, Mr. Nayak?
My lord,
It
102,
is a dispute
102
between
D.
a society
C.
and an individual. It's a dispute between society and an individual. Who's
No, no,
there
no, no,
talking-
no.
who's there the-
Society, that's my lord, C is otherwise.
who are
Between
the
the,
parties, sir?
no, no,
Can you please come to the agreement?
kindly, no, agreement, my lord, I'm coming to that.
Yes.
My lord, since I'm referring the section, whether it covers two different society or not.
It's not about two societies.
Yes. My lord, B, I have read, my lord, I have read, referred there, respond number 2. Who are respond number 2, my lord, 1? They explained. And he is the director of another society. It is the cooperative society, 1 petitioner, and 2 is the director of another society. And my lord, the agreement has been entered into. Therefore,
Please see the agreement, sir.
my lord, I am reading it 1 second. Kindly, my lord, kindly, my lord. My lord, 102, C says, between the cooperative society or its board and any past board, any officer, agent or employees, or any past officer, past agent or past employees of the nominee years, legal years, so and so. My lord, D kindly, my lord, this applies in D. Between two cooperative society or between a cooperative society and a liquidator of another cooperative society, or between liquidator or two different cooperative, or between a cooperative society and any person having transaction with it. The society, or even if any person having transaction with it. My lord, respond number 2 and 3, as they are saying, my lord, even if not another cooperative society, but a person having transaction with in petition number 1, which is covered under my lord D, 102D, squarely covered, in my humble my lord understanding, it covers. And my lord, their remedy is available 103. Arbitral procedures are there, mechanism is available over there. And my lord, this is a self-contained code. Even the arbitration proceeding or any order thereunder is not acceptable by any of the party, then appeal is there, and my lord, appellate tribunal is there. So any order under 103 is appealable order before the tribunal, thereafter High Court. So this mechanism is provided in the Act itself. Now the person is saying that if I avail this mechanism, there is no bar at all. I say it is absolutely bar, because you are the creator of this statute. You will have to show that you have availed it. Why you are not willing to avail this opportunity? Because they have missed the parts. From the date of cause of action, they will have to approach within a certain time. That they have not done. Now they are saying that after serving notice under 21, they can come up with this and they can avail opportunity of another different forum. Now, my lord, they have referred one judgment also, where they are saying that it is not a bar at all. It is absolutely bar, because in the first judgment of 2021-17 Supreme Court, both parties acceded to it, accepted, participated. Tomorrow judgment it is to refer korle. There are two honorable members, honorable judge of the honorable High Court, and not I will show 3 judges bench. Thereafter, I am referring lordship. Here it is said both the parties acceded to it, accepted, participated in the arbitral proceeding. Ultimately, order was not satisfactory. They may not preferred. They went up to Supreme Court. Supreme Court held on the ground of biasness or partiality. The chairman cannot be the arbitrator. It was accepted and it was set aside. So when the parties accept the arbitral proceeding, participated it, he cannot refer, he cannot say at this stage, no, it is applicable for me. But I will submit, this is a different case. At the very initial stage, our submission is this, all procedures, because the creature of statute, you are the creature of statute, register is there, 102 says you have to approach them, and thereafter the appellate provision is there, arbitrations will be applicable over there. Then why it is not accepted? It is not accepted because they have not approached the court within a month. Thereafter, they are coming after a long period of that. Now they want to rest upon with the notice under section 21. My lord kindly says, this, Lord, I say, my lord, this 21-17 Supreme Court is not applicable because both the parties were party to the proceeding. And my lord also says the issues in that judgment, my lord, page 9. Kindly come to page 9 of that judgment, what they referred to. What were the issues before the court? Page 9, my lord, internal page. 1, 2, 3. Lordship, kindly come to internal page 3. Below the issues of determination before the Supreme Court. Has your Lordship got it? 1, 2, 3.
Yes.
Page 3.
Yes.
Whether the appointment to arbitrator by court under section 11 of this cat, other than the designated sole arbitrator is invalid. Number 2, whether chairman Sekhan Singh cannot be held to be ineligible, which was held ultimately eligible. 3, whether in view of section 58 of Rajasthan Cooperative Societies Act, arbitrator other than sole arbitrator can be appointed by court under section 11. And whether the High Court committed any error in appointing arbitrator other than the designated sole arbitrator. These were the issues which were discussed in the judgment. Here, none of the milord issue is that parties are not participating. They are taking the point of maintainability and having their milord proper provisions of law and complete code available to them of this Arbitration Act, whether this particular section 11 application will apply or not. This issue was not there, which I am raising before Lordship. Their parties accepted it, acceded to it. Then, milord, they challenge later on the judgment. So it is a different judgment which is not applicable in our case. Now, milord, kindly come to a judgment, milord. লটটা কোথায় গেল? এটা সবগুলো এখানে? কেন পড়াচ্ছি সেটা? And milord, kindly take up this judgment. Milord, 3 judges bench, milord, Justice Palin Nariman, Aniruddha Bose, milord, my lord, his lordship, the Honorable Justice Bose, was a party to this in the judgment. And milord, I am referring 3 judges bench judgment, milord, paragraph 28. Kindly have a look to this. এক সেকেন্ডে একটু দাঁড়াও। হ্যাঁ লিখো 2020 the 1917 SCC 82 হ্যাঁ দিতে পারতাম কিন্তু পাচ্ছি না এখন। 2019 17 SCC 82 Hindustan Zinc Limited. Paragraph, milord, 28, lordship, kindly come. Section 86(1), milord, this is a fight, milord, under the Electricity Act, where, milord, the State Commission's creation and power is described, and milord, with the, milord, the contractor. Now, milord, here the dispute was referred to arbitrator by the State Commission. It is held. The State Commission itself is authorized under the statute to take up the matter. They cannot put any arbitrator under section 11. Here the case is, lordship, kindly see for a moment, just I am reading it.
Analogy will not work in this matter.
Milord, may I just place 4 lines? Milord, section 86(1)(f) is a special provision and hence will override the general provision in section 11 of the Arbitration and Reconciliation Act for arbitration and dispute between the licensee and generating company. It is well settled that the special law overrides the general law. Hence, in our opinion, section 11 of the Arbitration and Reconciliation Act 96 has no application to the question who can adjudicate the dispute between licensee and the generating company. Here, milord, in my humble submission, milord, section 11 of the Arbitration Act is, milord, a general act, and milord, Cooperative Societies Act 102 and 103 is a special act, and that will override the provisions of this. This is what, milord, I am relying on. And another judgment, and this is also, milord, the 3 judges bench judgment of the Honorable Supreme Court, where one of the Honorable Judge was Mr. Justice Bose. Another judgment, milord, I am referring scale 520. Paragraph 19, lordship, kindly come to paragraph 19 and 22. দিলাম যে তোমাকে বললাম যে ইয়ার অনলাইন হ্যাঁ এটা না ওটাতে নেই National Highway Authority.
NHA versus
Law Authority. Tea Company.
Hyderabad Tea Company.
Yes.
Paragraph 22, Lordship. The very question arose before the court whether the application under section 11(6) of the Act is maintainable in view of statutory provisions of the Electricity Act, adjudicating the dispute between the licensee and the generating company of the special enactment, and section 86(1) of the Electricity Act, in particular this court in Gujarat, Urja Vikas. Now, my lords, 86(1) is a special provision, and hence we override the general provisions of the law. That is, my lord, 28 is saying so. And paragraph 19 also, I am referring just for a moment. It is settled principle of law that when the special law set out a self-contained code, the application of general law would impliedly be excluded. And in the instant case, the scheme of the Act 56 being a special act enacted in the line of purpose of this, and the appointment of the arbitrator by the central government under section 3G(5) of the Act 56 and subsection 6 of the section 5(3)(g) itself clarifies that subject to the provisions of this Act, the provisions of the Act 96 shall apply to every arbitration absolutely to the extent where the Act is silent. But here is Act is not silent, my lord. That will apply if Act does not provide any relief. Therefore, I say, my lord, in view of this, and three judges bench the observation, lordship, of the Supreme Court. And one more judgment, my lord, I am relying on. This is 59 and 60, lordship. Kindly have a look to this. Of this. Urja Vikas Limited. Or 2008 March. 59 and 60. 59, my lord. In the present case, it is true that there is a provision for arbitration in the agreement between the parties.
Which
Stated, my lord, 96. Had the Electricity Act not been,
paragraph?
my lord,
Which paragraph?
paragraph, my lord, 59 and 60.
All your matters the same. You are pointing out the same
Gujarat Urja Vikas, my lord.
proposition. Same proposition. All three matters.
Same proposition, but it is not clearly
To show
stated that
three
in
judgment
60.
on the same proposition.
No, my lord, only paragraph 60, my lord, speaks a bit different. We make it clear that it is only with regard to the authority which can adjudicate or arbitrate disputes by the Electricity Act will prevail over the section 11.
Same thing you have pointed out in all the three.
Now, my lord, what I am on is, again, my lord, I am saying that since, my lord, this Act provides remedy, so that will prevail over, my lord, section 11 application. That's the only point I am taking. Because lot of interstate disputes are there. Parties are making allegation, counter allegation.
Yes.
Correct. My lord, in our affidavit also, my lord, if your lordship kindly takes up our affidavit in opposition, yes. Three, I have the point I have taken on maintainability in paragraph 3 that I have argued. The instant application is not maintainable either in law and fact. The petition number 1 is a cooperative society, Registration of Cooperative Societies Act. Petition number 2 claims to be director of petition number 1. And the issues involved in the petition are revolved around the Cooperative Societies Act and rules, regulation thereunder, and also to be guided by the relevant bylaws of the society. The West Bengal Cooperative Societies Act is referred to here in WBCC Act, which is a special act and a complete code in itself. And the provisions of the Act overrides the provisions of other law for the time being in force. Any dispute arising out of the transactions connected with the society is amenable under the Act, and the same should be resolved under the mechanism created in the Act and rules thereunder. The Arbitration Act having no application in the instant matter. And the complicated issue referred to in petition can be resolved under the dispute redressal mechanism of the West Bengal Cooperative Societies Act itself. And then, my lord, kindly come to paragraph 17, my lord. That's the specific allegation we have dealt with, my lord. Second paragraph, paragraph 17(2). I say that there is no need to intervene of arbitrator and dispute arose due to non-payment of payable and agreed amount to the respondent number 1 by the petitioners, and if the petitioner pay the outstanding amount to the petitioner number 1 as per his own undertaking in terms of the registered agreement, all disputes can be mitigated and settled. In this context, I further say that the contention made in paragraph 16 are true, and the power of attorney dated such and such has been revoked. So, my lord, some facts are there which requires we are triable, and some are not triable. Admitted facts are there also. But the whole contention is this: all the questions can be adjudicated under section 103, and it is not their averment that they are not coming under 102 any paragraph of the writ petition, or 103 is not applicable in there. Therefore, having total application and, my lord, total remedy available, they cannot bypass it. In that even everywhere, because I have read the Electricity Act, my lord, the Supreme Court bench has said, because Electricity Act is a special act, they are giving you the provisions and the remedial measures are there. You ought to avail it. Don't go for the arbitration. Then, my lord, the Highways, National Highways Act, the same thing has happened, my lord. The remedy is available there. You avail it. Don't go for Arbitration Act. So same contention, my lord, I am making before lordship, and I say, my lord, this petition may not be entertained. It can be relegated to, my lord, a complaint before the arbitrator as per 103.
Respondent number 2 is not a proper party. Why I'm saying so, my lordship? On January the 1st one, the original agreement which he was not a party. Second, on November 9, 2022, was made a party as an investor, my lordship. There was no arbitration clause. Then, my lordship, on 26th of February 2025, the final agreement was made between the petitioner and the respondent number 1. In the meantime, the respondent number 2 has already left the agreement, which is admitted fact, my lordship. But on the party, then how?
Yes, how are you dragging them into
My lord, if I may rebuke to my learned friend appearing for the respondent number 2, my lord. My lord, the sole contention raised by her is that the respondent number 2 is not a party, my lord. I would invite your lordship's attention to page number 56 of our petition, my lord. My lord, this is the tripartite agreement whereby respondent number 2 weigh into this entire fiasco. The very last paragraph, if I may read it out, may I, lordship? And whereas now on negotiation between the aforesaid parties, it has been agreed to enter into this agreement on the following terms and condition. This agreement will become an integral part of the development agreement by number 333/2022. My lord, that is the original agreement, my lord. Therefore, my lord, this submission on the part of respondent number 2 that he should not be made a party does not arise, my lord, is untenable. My lord, thereafter, after few years, my lord, silently respondent number 2 took his steps back. When it was decided between the respondent number 1 and the petitioner before your lordship that okay, the remaining construction work which was lying pending at that time will be constructed jointly in absence of respondent number 2 by the petitioner and respondent number 1, and they did that. And while doing so, they rearranged or redefined their profits, my lord, which will appear at page 61
But I have
at the
Just a
very end.
minute, Mr. Nayak. Let him make a submission. Yes.
My lord, para 6 onwards at page 61, my lord, the new arrangement was made that how respondent number 1 going to keep his share and how the petitioner before your lordship will retain his profit. Now, my lord, if I may address the contentions raised by my learned senior friend appearing on behalf of respondent number 1, my lord. My lord, the very first contention of my learned senior friend was that it was a fight between two cooperative societies. My lord, it is not relevant fact that what post respondent number 2, a respondent number 1 is holding. As your lordship rightly pointed out, that everywhere in all these 3 documents, he has been defined as the owner of the particular land over which the development was made, my lord. And it is not in dispute, my lord. In their objection also, they have not taken this point that it is between two cooperative society. It is between the petitioner cooperative society who entered into a commercial contract with this respondent number 1, my lord. And now, my lord, with regard to, my lord, the 3 judgment placed, which I had a glance, my lord, both 3, as your lordship again pointed out rightly, dealt upon only one issue, my lord, that too concerning Electricity Act, in particularly section 86(1)(f), my lord. 86(1)(f), if I may read it out for your lordship, stipulates the state commission shall discharge the following function. There, my lord, it was defined what state commission will do. Adjudicate upon the dispute between the licensee and the generating company, and to refer any dispute for arbitration. Their entire duty and role was defined within a very non-pierceable core, my lord, if I may say so. And for that reason, section 11 cannot be invoked, my lord. In stark contrast to that specific judgment, before I say so, my lord, what my learned friend, senior friend put stress upon is regarding the fact that the 3 judges bench of Hindustan Zinc, my lord, was presided over by Justice Aniruddha Bose, my lord. The same, and my lord Justice Aniruddha Bose has also pleased to pass the order which we are citing, Jila Parishad Supra, my lord. My lord, my humble submission is that his lordship was conscious enough to grant all this situation, especially this section 86(1)(f) of Electricity Act and the bar of section 11. My lord, here in Cooperative Act, there is no express bar that this dispute cannot be adjudicated by a arbitral tribunal after the same be referred by this honorable court under section 11. Rather, my lord, the Jila Parishad judgment was clear enough and has settled the dispute forever, that when there is a commercial contract existing between a cooperative society and another individual, they have consciously made the choice, they have agreed consciously to the procedure in case any dispute arises, what will be done, and on the basis of that conscious decision, the section 11 will be invoked, and my lord, this dispute should be referred before the tribunal, my lord. This is my humble submission, my lord. before your lordship.
Yes, Mr. Nayak, you were saying.
But I respectfully submit, my lord, this is very clear when, my lord, a statute provides remedy. My lord, the only point what my lord was pleased to, my lord, raise, my lord, it is not, they are not society and all that. My lord, I am again reiterating at the cost of, my lord, reiteration, lordship, kindly excuse me. 102D I am referring. Between two cooperative societies and between a cooperative society and any person having transaction.
If I may, my lord.
102D.
Just a minute.
My lord.
102D, lordship, kindly kindly considered. Whatever the merit is, Lord, I have not placed any argument on the merit. I am simply saying the parties are covered under 102D. Even if he is not
I've
suicide.
heard that. All
My
right.
lord, only my
So,
lord,
my lord,
one indulgence.
I
If I
reserve my
may,
right, if my lord at all, please, my lord, to hold that it is maintainable. My lord, obviously on merit, my lord,
You
lot of-
challenge the order. I will hold it to be maintained.
my lord,
Lord.
if I may
Reserved.
make a submission, my lord. My lord,
Now you want to make more submission?
no, my lord.
After
Only, my
hearing the
lord.
view?
No. Only that, my lord, it is regarding internal
What of-
dispute, 102 and 3.
My lordship, respondent was never served with an application, the notice of under section 21, my lordship.
Served, my lord. It was served, my lord.
No, it
Where was it served?
It has been annexed, my lord. What my learned friend is,
File the copy.
no, my lord. It has been served.
number 79.
If your lordship kindly take section, page 86, my lord. It has been served, my lord. Copy to Chondo Construction, my lord. Chondo Construction's proprietor is respondent number 2.
It was addressed to respondent number 1 only, my lordship.
What do you mean copy to? Huh?
My lord,
What
that
is
has
copy
been
to?
done. My lord, it was copied to my lord.
Respond number 2 can't drag them into this.
My lord, but he's a necessary.
Should have served a 21 notice.
After exit of respondent number 2.
আমাদের ওখানে দুই করা ছিল ওনার কথা।
Affidavit reply filed by the petitioner to the affidavit in opposition of respondent number 1 and 2 is taken. Save.
My lord.
Lordship. Grateful, lordship.
My lord.
Number 8.
I appear for the respondent number 2, my lord.
On it, I'm led by Mr. Jishnu Shaha, sir.
I appear for the petitioner. I'm being led by Mr. Shurjit Nath. My lord, here these matters, my
Well,
lord.
we have, my lord, almost settled the matter. My lord, essential terms have been agreed upon. It is only stuck on one, my lord, small issue. That is, my lord, how do we take care of the urban land ceiling problem? My lord, I think that problem can also be addressed. If your lordship, my lord, adjourns it for another 2 weeks, I think, my lord, we'll able to come back to your lordship with a settlement.
Now, subject to what Mr. Shaha says, the section 9 is fixed on the 24th of April. Let both matters appear together. We will be
Yes,
able to.
yes, I think that will be appropriate.
There's a connected section 9 application fixed on 21st of April. My lord, we'll keep this matter on the same date. That will, my lord, perhaps we'll be able to come.
All right. At the request of the parties, learned counsel for the parties submit that settlement talks are underway. They pray for an adjournment. Let this matter be listed on 21st of April.
Grateful, your lordship.
Gratefully.
Item number 9, your lordship, this is my application
I'm
under
opposing,
section 11 of the Arbitration and Conciliation Act for appointment of an arbitrator. Now, the dispute, your lordship, basically, your lordship, is a leave and license agreement executed between myself and your lordship, my learned friend's client. Now, the agreement for license, your lordship, is for installation of a hoarding, your lordship,
I'll
in my.
just come back and find.
Yes.
I'll just.
This is my application, Your Lordship, for appointment of an arbitrator. Lordship, the dispute between the parties are, Your Lordship, the petitioner executed an agreement for license, Your Lordship, for the installation of a hoarding in Your Lordship, our land, so that they can advertise, Your Lordship, their name from that particular area. Now, your two agreements were executed. First agreement executed in the 2014 that expired. Subsequent agreement which was executed sometime on 1st of November 2021 that also expired. If Your Lordship kindly come to the agreement once. The agreement is at page 14. Your Lordship, that was the latest agreement. Page 14, Your Lordship.
14, 1-4.
1-4.
This is the first agreement. No,
This is
second
the
one.
first agreement.
No, this is the second one, 21.
This is the second one, Your Lordship. 2021.
First
Now,
is 2014.
2014 agreement I annexed, Your Lordship. That is at page 11.
Yes. Yes.
Now, this agreement, Your Lordship, contains an arbitration clause that is at page 20. Page 20, clause number 9.
Yes.
Now, Lordship, this agreement was expired, Your Lordship, on 31st of October 2024. And they have given us a letter saying so, Your Lordship, that if we refund Your Lordship regarding their security deposit, they will dismantle, Your Lordship, the entire advertisement and go away. That letter, Your Lordship, is at page 22. August 2025, Lordship, kindly take page 23, second last paragraph. It is therefore requested that your office may kindly note that the date and time mentioned herein and allow us to dismantle and remove the advertisement structure from the premises of Agri Horticulture Society of India. If your office would have any issue with regard to the date and time mentioned, please feel free to inform us as the same, and we shall mutually decide and schedule an alternative date and time for carrying out the work for removal of the advertising structure. So we were under the impression, Your Lordship, that if Your Lordship, the monetary parties settle, they'll dismantle the particular, Your Lordship, hoarding and go away. There was no dispute. Suddenly what happened, by suppressing this particular arbitration clause, they have gone before the Alipur court and obtained an order of injunction. That order of injunction is at page 24.
Move an application.
I filed an application under section 8.
Yes.
Thereafter, when I given them a section 21 notice, they have given a reply, and only standing, Your Lordship, stand they have taken that section 8 is pending, suit is pending, so you cannot initiate the arbitration proceeding. It's completely contrary to section 8, subsection 3. It's their claim. They can go anywhere, but my claim, Your Lordship, they are still in possession. They are exploiting my particular area. I have a right, Your Lordship, to invoke the arbitration clause and Your Lordship recover and take mean profit from them. From them, Your Lordship, kindly take, Your Lordship, the invocation letter which I have given them. That section 21 notice is at page 30. And they have replied, this particular notice, Your Lordship, is at page 37. And the reply only states, Your Lordship, that the pendency of the suit and the section 8 application. Because that is the only defense, Your Lordship, which they have taken, Your Lordship. My suit and Section 8 is pending, so you can't invoke the arbitration clause. It's their suit, it's their claim. Your Lordship, my claim, Your Lordship, has to
If
be.
your application decided, Section 8 application, then you come here.
The next date
No, Your Lordship,
fixed
this-
on
Kindly take, Your Lordship, I have
11th of
checked the
May.
law, because once they have taken the stand, Your Lordship, kindly take two provision. One is Section 8, subsection 3, and I'm showing Your Lordship the Supreme Court judgment, which clearly says that there is no bar. Because that's their ploy, Your Lordship. They never, Your Lordship, go there. Section 8, subsection 3, Your Lordship, kindly take Supreme Court. 8, subsection 3, notwithstanding that an application has.
Yes.
8, subsection 3, notwithstanding that an application has been made under subsection 1 and that the issue is pending before judicial authority, an arbitration may be commenced or continued and an arbitral award made. Now, Your Lordship, this particular clause, Your Lordship, has been interpreted by the Honorable Supreme Court. Only one paragraph may just show it. Paragraph 12.
citation.
Copy this. Copy আছে না? আমি কোনটা বলবো? Okay, thank you. Kindly take paragraph 12 once. Para 12, having regard to the specific provision in section 8, subsection 3, providing that the pendency of an application under section 8, subsection 1 will not come in the way of an arbitration being commenced or continued, we are of the view that an application under section 11 or 15(2) of the Act for appointment of an arbitrator will not be barred by pendency of an application under section 8 of the Act in any suit, nor will the designate of the Chief Justice be precluded from considering or disposing of an application under section 11 or 15(2) of the Act. Identical, another, I can show Your Lordship other high courts, Your Lordship, views. Your Lordship, they have all along, Your Lordship, appointed, Your Lordship, the arbitrator. Because today, Your Lordship, what has happened? He has gone and filed a suit, Your Lordship, taken an injunction after suppressing this arbitration clause. There may have a claim. I cannot file a written statement there and cannot agitate, Your Lordship, my grievance. So I invoke section 21 notice, and once the arbitral tribunal is constituted, Your Lordship, I will file appropriate applications for my protections. Now, to the situation is that, Your Lordship, they are staying, they are utilizing the property without paying me a single penny after the expiry of, Your Lordship, the agreement. सूर्य पलटा दो.
Yes.
No, my lord.
Anything else?
So I can show Your Lordship the Madhya Pradesh High Court's judgment. Our Honorable Chief Justice, Your Lordship, was there at that point of time taking section 11 application. The same proposition, paragraph, Your Lordship, 13 and 14. Lordship interpreted, Your Lordship, section 21 and then, Your Lordship, 8, subsection 3. To kindly see paragraph 13. Section 21 of the Arbitration Act makes it clear that unless otherwise agreed by the parties, the arbitration proceedings regarding particular dispute commences on the date on which a request for referring the dispute for arbitration is received by the respondent. Despite specific question from the bench, learned counsel for the parties did not point any provision of the shareholder agreement which deals with the agreement of the parties, but the arbitral proceeding releases in 21. Thus, the arbitration proceeding under section 21 would be treated to have commenced on the date when a request for the reference of the dispute was received by the respondent. Section 8, subsection 3 of the Arbitration Act makes it clear that even if an application under section 1 of 8 is pending, arbitration may commence or continue. An arbitral award can be made A combined reading of section 8, 11 and 21 of the Arbitration Act makes it clear that section 8 and 11 are independent proceedings and can run simultaneously stroke concurrently. And thereafter, your lordship appointed your lordship the arbitrator under section 11. These are my submissions, your lordship. Then the arbitrator may be appointed, your lordship, once I have invoked the arbitration clause.
Yes.
Lordship can see para 20 also, your lordship.
Well, at the very outset, I say that there is no bar while deciding section 11 application, even if there is a pendency of section 8 application. This is a settled law. But I have a twofold submission. Number one, the initial agreement, there is no arbitration clause. The agreement, the second agreement, which is of 2021, there is an arbitration clause which the agreement expires in the month of October 2024. Now, I filed a suit, obtained an order of injunction. They filed an application under section 8 that is still pending, and the 11th of May is the next date fixed. Now, your lordship knows very well that it is a settled law that any order passed in section 8 application that becomes a res judicata in section 11 application. Delhi High Court of judgment. Kindly consider the 2015 Supreme Court. Kindly consider paragraph 9.
That's a different proposition altogether.
In this particular case, the section 8 application was rejected, and thereafter they filed an application under section 11. The court held that since the section 8
Not the case here.
this is not the case. I am coming to that.
Yes.
The court says that it will operate as a res judicata and estoppel. Now, kindly consider section 10 of the CPC and section 11 of the CPC. The principles between section 10 and...
Forget about CPC, sir. You let us concentrate on the Arbitration Act. All right.
Now, what I am trying to say, that if an order passed by a competent court...
You try to distinguish the Supreme Court judgment. That is the only contention you have?
My only submission that it's a premature application, and on the month of May is the next date fixed. Can take it up this matter after.
Why should I?
I'll
decide it right now. It is absolutely maintainable. I'll appoint an arbitrator.
Yeah, that is at the very threshold. I say there is no bar.
No bar at all. Either you consent to it or whatever you want.
Can appoint but by court's order, it's not.
Take down. The petitioner has preferred the present petition under section 11 of the Arbitration and Conciliation Act seeking appointment of an arbitrator. Full stop.
Section 8.
You have filed your reply now? Is there any reply also?
No, there is no.
The petitioner states that the parties had entered into an agreement dated 8th October 2014 for display into a lease agreement for putting up commercial advertisement hoarding space of 6,000 square feet to be located at the boundary wall of Belvedere Road and Alipur Road, property belonging to the petitioner. The said agreement was further this came to an end when the first
It came to an end, Your Lordship, 31st October 2024.
31st October. No, the first one. The first agreement.
First one. First one, Your Lordship, and
For a period, this was for a period of
stuck on 3 years, Your Lordship. That was only for 3 years. That was expired in 2017.
the said agreement was for a period of 3 years and had expired into the 2017. The parties entered into a fresh agreement
On 1st November 2021.
on 1st November 2021. Same amount or amount changed?
Amount, Your Lordship, increased 1,20,000, Your Lordship, now. Change, Your Lordship. 1,20,000 now the license fees.
On a separate commercial fees for display of the hoarding as mentioned in the first agreement as well as the second agreement. First, learned counsel for the petitioner further states that the agreement itself, which is where's the arbitration clause?
Yes, Your Lordship. Page 20. Clause number 9.
The petitioner states that the agreement itself contains an arbitration clause which is reproduced herein as clause number 9, which is reproduced herein. The same is not disputed by the learned counsel for the respondent, though the respondent, learned senior counsel for the respondent states that the respondents had filed a title suit number 1282 of 2025, which is pending adjudication before the Civil Judge Senior Division First Court, Alipur. Wherein the stay has been granted.
Junction is there.
Page 25, Your Lordship, the effective portion. Bottom.
Wherein his prayer for ad interim order of temporary injunction was allowed. Full stop. Learned counsel for the respondent states that the present application is not maintainable since the title suit number 1282 of 2025 is pending adjudication, and that the petitioner's application under section 8 is also pending before the Civil Judge Senior Division. Full stop. That's the only contention. Full stop. Third, upon consideration of materials placed on record and the submission advanced by the learned counsel for the parties, this court is of the opinion that in terms of section 8(3), which provides that pendency of an application under section 8 will not come in the way of an arbitration being commenced or continued. So कर दो, ऐसे कर दो, that in that the issue heard so and so, the issue is no longer res integra. The Honorable Supreme Court in Vijay Kumar Sharma alias Manju versus Raghunandan Sharma alias Baburam and others, 2010 to SEC 486 has held as under para 1230. In view of the said proposition, the contention advanced by the learned counsel for the respondent is no longer res integra, and the same has been decided by the Honorable Apex Court. Since the agreement between the parties have been admitted, and that the arbitration clause contained in the said agreement provides for a redressal of dispute in terms of by way of an arbitration, this court is inclined to entertain the present petition and is satisfied that the agreement is in place and that an arbitrator can be appointed in terms of section 11(6) of the Arbitration and Conciliation Act. Full stop. In view of the same, this court appoints. How many years you have put in?
20 years.
Mr. Give your name. Mr. What's your name?
Arnav Chakravarti.
Mr. Arnav Chakravarti, as the sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned arbitrator shall act in terms of section 12. Full stop. The remuneration shall be fixed in terms of Schedule 4 of the said Act. Full stop. A copy of this order shall be communicated to the learned sole arbitrator.
My lord, only prayer, my lord, that
yes,
this order, my lord, without prejudice to the right of the parties in the section 8 proceeding, my lord.
What section 8?
His suit, my section 8.
That's your suit.
Their section 8 application, my lord.
Section 8 application, nothing survives in section 8 application. With the opposite direction, the present application is disposed of.
Grateful, Your Lordship.
Get out.
So this is my application under section 11 of the Arbitration Act. The petitioner here is a bank and the respondent is also a bank. Dispute has arisen in respect of the property which has been offered by the borrower, Ma Durga, proprietor Subhashis Tripathi. The same property has been offered as a security by the borrower to both the bank, it appears. Now, my lord, the petitioner's officer, while checking into the portal of the, into their portal, their normal called banknet.com, has come to know that with regard to the very same property, the respondent has also issued a notice under section 13(4) of Surface Act to take possession or sell whatever step under. Now, Surface Act, my lord, section 11 categorically provides when there is a dispute between two financial institutions with regard to the property or the title of the property, then that matter shall be referred to the arbitration. It is a mandatory provision. My lord, here, the fact of case of my client is this, that the borrower, that Ma Durga proprietor has taken a loan from my client for a sum of rupees 24 lakhs. Then they created a mortgage, and that mortgage has also been registered by my client before SARSAI. SARSAI is a central registry office for particularly created for the banks, where any property is mortgaged, then it has to be registered there, so that all banks all over India can understand that these properties mortgaged with this particular bank. Milord, then borrower defaulted. My client, as on their request, offered one-time settlement, that is OTA. That also has been there. Also, they have failed. Then on 7/11/22, bank has taken symbolic possession. Thereafter, bank issued notice under section 13 or 14(1) of Surface Act and made an application before magistrate to take possession of this property. Then magistrate has also annexes Z. I have annexed to my application at page 180, second volume, where the magistrate has also allowed my client to take possession of the said property. Thereafter only it has come to the notice of the
Magistrate is just
officer
a
of the bank.
facilitator, madam, under section 14.
My lord?
Magistrate is just a facilitator under section 14.
My lord. My lord, the property is in our possession right now under section 14 because our order is prior to that order. Our mortgage is also prior to their mortgage.
That dispute has to be resolved before the arbitrator, because I'm saying mine, whether prior or not, who
Where's
is
the
holding
contract between
original
both of you?
document?
My lord,
Where's the contract between both of you?
there is no contract between both of us.
No, this is that when there is two financially. May I read out the section 11 of Surface Act, where here question of contract cannot come because two are independent institution and the borrower has mortgage. I think separation, upon separation, whatever, the statute says where any dispute relating to securitization or reconstruction or non-payment of any amount due, including interest arising amongst any of the parties, namely bank or financial institution or asset reconstruction company. Here my client is the bank, the respondent is also bank, or financial buyer. Such dispute shall be, it's a mandatory provision, shall be settled by conciliation or arbitration as provided under Arbitration Act. As if parties to the dispute have consented in writing for determination of such dispute by conciliation or arbitration, and provisions of the Act shall apply. Here, after coming into know of this, their steps, we gave them notice to stay their hands because original documents are lying. They have not. As such, a dispute has arisen, and section 11 of Surface Act comes into operation because, my lord, sir, under Surface Act, DRT cannot decide title. When two banks are under section 19 of Recovery of Debt and Bankruptcy Act 1993, also DRT has no power. It becomes a civil dispute. Here, to resolve this type of problem, a special amendment has been made out and section 11 has been introduced. My lord, in this regard, I am relying, your lordship will take paragraph 42 at page 23. At page 25 of my application. wherein Honorable Supreme Court in this matter has decided. Section 11 of SARFAESI Act deals with resolution of disputes relating to securitization, reconstruction, and non-payment of any amount due between the bank or finance. This is applicable to me. Then, in order to attract Section 11 of the SARFAESI Act, twin conditions have to be fulfilled. First, dispute must be between two banks. Here I have shown your lordship that dispute is between two banks. I have annexed all securitization documents while taking loan in my this application. Secondly, the dispute must relate to securitization and reconstruction or non-payment of amount including interest, where aforesaid two conditions are found to be prima facie satisfied. There the DRT will have no jurisdiction. Now, even if I go, DRT will have no jurisdiction. My learned friend's client goes, will have no jurisdiction. And the proper recourse would be Section 11 of the SARFAESI Act. Then, there in the point 5, para 27, Section 11 of SARFAESI Act, Honorable Supreme Court states that is a mandatory in nature. The use of the word shall therein, the mandate of the provision cannot be bypassed or subverted by the parties by seeking recourse elsewhere. In this regard, my lord, I am also relying upon a judgment of coordinate bench of this honorable court, my lord, wherein in the identical matter, my lord,
citation is
না সাইটেশন এটা কপি আপনাকে দিয়েছি
আচ্ছা আচ্ছা এইটা কি 870
Yes.
Such, my lord, I am praying your lordship to appoint an arbitrator who will decide as to whether my learned friend's client or my client is having title with respect to the property.
My lord, regarding this decision, whether it is an arbitration by fiction of law, my lord, that is, being an officer of the court, I should, my lord, place the law. What is the law, my lord? This is the decision rendered by the Honorable Supreme Court.
The same on which you
Same order.
7110.
My lord, 7-1.
Same, that's the very same order.
I'm just placing the judgment, my lord. So, my lord, I do not have anything to say regarding that, my lord.
Then get the
Just a
arbitrator
second.
appointed.
But, my lord, this question was also raised by me on the earlier occasion before, my lord, before the coordinate bench.
Yes.
There is no notice under section 21, my lord. Because section 21 notice, my lord knows very well, is
Not
a
in
notice,
this special circumstance.
even, my lord,
Where-
that is
where
not
does the
even
Supreme
done
Court
away.
say that you have to-
Because, my lord, kindly sees all the intersect arbitration act will come into play. When section 11 is coming into force, my lord, by dint of section 11, the entire arbitration act comes into play. As if it will be dealt with under this arbitration act. No more Surface Act, section 11 of the Surface Act brings in the entire arbitration act, arbitration conciliation act, because the arbitration will follow, arbitration tribunal will follow after section invocation of section 11. Surface Act will have no application in that arbitration, my lord. There is no room for the Surface Act to be applied there.
No. That argument is.
My lord,
you show me some authority on this.
My lord, here I have given notice. At page, your lordship will see my
that
notice is
not-
already there.
not under section 21, my lord. Kindly see.
Section 21, when there is an agreement between the party, then only
This can't be
section.
How can it be under section 21?
It is a deemed agreement. It is a deemed agreement under the section 11, my lord. Kindly see. May I
I've
read?
given notice that kindly your lordship will look into
page
second volume.
Show me some authority.
Well, I'm coming. Well, I may read,
Yes, page.
read out the section 11, my lord.
Just a minute, page.
Hello?
Page notice.
I'm giving page. Page 20.
My lord, page 203. Second volume, my lord. Second volume.
Yes.
My notice is dated
6 February.
6 February 2026.
Yes.
Yes, my lord. So, my lord, according to me, this is the not a notice under section 21, first of all. Second of all, my lord, may I read out for my sake, my lord, section 11 of the Surface Act. My lord. Where any dispute relating to securitization or reconstruction or non-payment of any amount due, including interest, arises amongst any of the parties, namely the bank or financial institution or asset reconstruction company or qualified buyer, such dispute shall be settled by reconciliation or arbitration as provided in the Arbitration and Conciliation Act. My lord, I'm putting emphasis on this act, as if the parties to the disputes have consented in writing. So it's a deemed agreement, my lord. Writing for determination of such dispute by conciliation or arbitration, and the provision of the act shall apply accordingly. So it is a deemed agreement, my lord, and the provision of the entire act shall apply accordingly, my lord. So, my lord, may I come to this? Is this judgment, my lord? ওই আগের দিন 2025 ভলিউম 9 SCC 689 6 হ্যাঁ আছে 686 হ্যাঁ আপনি এটা নিন Well, I'm straight away coming to page 701 of this judgment, my lord. There are three criteria that have been fixed. Why section 21 notice is required. I'm placing just the third criteria. Third, an application before the High Court or this court under 701. Under section 11(6) of Arbitration Conciliation Act for appointment of arbitrator can be filed only after the respondent has failed to act as per the appointment procedure in the arbitration agreement, and invocation of arbitration as provided in section 21 and the subsequent failure of the respondent to appoint its arbitrator or agree to the appointment of a sole arbitrator as provided under section 11.4 and 11.5 are necessary for invoking court's jurisdiction under section 11. So unless section 21 comes into play, my lord, section 11 of the Arbitration Act says that it is a deemed agreement and the entire Arbitration Act will be followed. If the entire Arbitration Act is followed, if it is a deemed agreement, my lord, then section 21 comes into play. If section 21 notice is not there, because it will indicate what are the disputes and from where the dispute, the limitation from where the dispute starts. It is an initiation of the arbitration proceedings, as my lord knows. So, my lord, if there is no section 21 notice, then the jurisdiction of section 11 cannot be, my lord, invoked. Because section 21 notice facilitates the parties of noticee to say whether he is agreeing to the arbitration or not. If he says he is not agreeing, he is not giving consent, if it fails, then only section 11 comes into play. This is my humble understanding, my lord, from the reading of this judgment.
May I make my submission, my lord?
Yes, yes, madam.
In this regard, I'm relying upon our judgment. এটা একটু দেবেন তো
কোনটা দিদি?
বোধহয় আপনাকে কপি দিই নাই কিন্তু
না না
দিয়ে
বলুন, থাকলে দিয়ে দিই।
Here this
ভাগীরথী
2026
আচ্ছা
Supreme Court online SC5, my lord. Here in this judgment, আচ্ছা একটা টেগ মার্ক করা আছে। Your lordship will start analysis. It's a huge judgment where this several rounds of arbitration has taken place between the state of Kerala and the party herein. And there, in this part, last, by concluding this, ultimately matter came up with regard to the issue and notice. There, the Honorable Supreme Court says, as your lordship will find in paragraph 14, একটু টেগ মার্ক করতে এখানে পেজ নাম্বার নেই, wherein the Honorable Supreme Court has said that failure to issue a notice and issue a section 21 notice would not be fatal to a party in arbitration if the
Yes,
claim is
madam,
otherwise valid.
Madam, which paragraph are you reading?
That's what if number
me.
is not there. It is there. This paragraph start at this is starting from paragraph 14, my lord. There the conclusion of the Honorable Supreme Court, the objection of the section 21. There the Honorable Supreme Court comes to the conclusion that
কোন প্যারাগ্রাফটা পড়ছেন?
paragraph actually 16. আচ্ছা এই নাও।
না ঠিক আমার কাছে আছে। I have a copy.
The non-mention of the section, a reference of section 21 will not be fatal. Notice is already given. It is not that notice is not given, but if reference of section 21 is not mentioned in the notice, it will not be fatal. That is what Honorable Supreme Court is saying. The mark, has your lordship got it?
This is slightly different, madam. This is only to the extent that if any claim has not been
Included.
put forth in 21 notice, that doesn't really preclude or debar or restrains any petitioner to claim it.
My-
That is the intention.
Yes.
The intention is not section 21 notice. Section 21 notice,
Section 21 notice is also says submission of the council. There
that's
it
only
has-
a submission of the council, but there's no finding on the 21 notice. 21
this is the
notice,
finding of they are relying
madam.
here.
Yes,
Finding starts, my lord.
yes.
And
If it is mandatory, then you give the notice, you come back. What is the difficulty?
my lord, notice to have given. Only mention of section 21
has-
is not there.
That has to be
That will
mentioned.
that will not frustrate their any claim, or that will not prejudice their any stage.
They say that it does. It does. That's what the whole argument is.
My lord,
They are saying it is
the,
not a notice
the
under
judge-
section 21. It is just a
my lord, the judgment which I have referred to of this coordinate bench of this
coordinate
very
bench doesn't talk about that,
Section
madam. You
21.
read it. You read it.
Yes, but there also only this notice was given, and thereupon, because this is a mandatory provision.
Madam, this judgment on which you are relying is regarding the claims. They are saying that if the notice doesn't contain all the claims, it doesn't preclude, it doesn't stop anybody from raising these claims at the time before the arbitrator. That is a distinction which is drawn between 21 and 23.
But when we gave them notice, they have not.
You have not given a notice. You have not given a notice under 21. Give a notice under 21.
If no mention of a particular section, if not it is mentioned, that will.
Then how can
not
it be
frustrate.
assumed? How can it? You show me any ruling on that? That if 21 notice has not been given, that will not frustrate.
My lord, the purpose of
This judgment is very clear.
My lord, purpose of the section 21 notice is to identify or determine the limitation.
That's right.
Here, when the officer of the bank came to know, immediately notice has been given.
That's not given under 21. That's exactly the argument which he's advancing, madam. That's what he's saying.
But my lord, this section 11 is not saying that. Section 11 is not saying.
Section 11 is saying that you have to act in accordance with the provisions of Arbitration and Conciliation Act.
And that act here, what this
Read
act
section
says,
11.
my lord,
The last line of section 11, please read.
if the parties to the dispute have consented in writing for determination of such dispute by conciliation, then the provision shall apply. Yes,
Oh,
not
no.
consented.
What are you saying? Just read it carefully. Don't read the way you want to read it, please.
I'll-
And the provisions of that act shall apply accordingly. And which is that act?
Arbitration Act.
That's exactly
But,
what he's saying.
my lord, here, if the party consent to the arbitration, then the provision shall apply. Here they have not. That is why I have come before your lordship.
There is no dispute as far as section 11 petition is concerned. The only technical objection which they are taking is that you have not served a 21 notice.
No.
They are not
In
saying.
that case, let him agree. Here, statute says, my lord, your lordship will.
So I'll record that they will issue a 21 notice. You don't have any objection.
Let them first, my lord, issue. I kindly do not record that. I do
This
not
is
have
a
objection.
technical objection. You are
But
just.
as if, my lord, it says as if it is a deemed agreement.
Now,
So
where,
let that be. See, you're agreeing to this.
As if it is a deemed agreement.
no, this
You're
is-
agreeing to this.
No.
Let us appoint an arbitrator.
As if,
No,
no,
you cannot
my lord,
disagree,
we are
my lord.
agreeing as if we are having an agreement.
All right, forget about everything. This court will appoint. You consent to it.
My lord, I
My-
cannot do that. That I
because-
Consent to it. Why? This technical objection is only for the purposes of frustrating it.
not frustrating,
Then-
my lord.
Yes,
We
my
are
lord.
having our
What is the
mortgage is
purpose?
prior in time. We have a judgment from the DRT. It is in our favor. Judgment of DRT in
You
our
go.
favor.
I'm not deciding your issue.
Section 14, we are in
Sir,
possession of the
wait
property.
a minute.
They have.
Wait a minute.
My lord.
Am I deciding the issue?
No, my lord.
Then why are you arguing this point?
Scope of 11, section 11 is very limited, my lord.
Go before the arbitrator if you are so sure about your case. What is the difficulty?
No, they are trying to frustrate our claim. That is the
Not at all.
That means he is.
They are more
But
than-
not at all.
That he has no.
Do you want me to find a way? I'll find a way.
No, my lord.
I'll appoint it. I'll find a way to appoint it.
No, I'm not kindly. do
That's
not take
exactly
me-
what you're trying
no,
to
no,
do.
no, kindly do not take me amiss, my lord.
You are.
No, my lord.
You're just acting smart.
No, my lord.
You're just trying to take the court here and there. Consent for the arbitrator's appointment.
My lord.
On the mere technicality of a
That I have to take
21.
instructions, my lord.
Take instruction, come back.
That I have to take instructions.
Don't do this.
Because I'm
Here, my lord,
I'm
he
acting on behalf
Otherwise,
of
you tell him, I know how to pass an order.
I am acting on behalf of an authority, my lord. Kindly cease. That is a difference.
I will distinguish the authority.
No,
you-
authority
you-
was statutory authority.
Yes,
that
you
I
go and ask them, come back. And I can tell you, I'll distinguish it.
know. That I know. Kindly do not take me amiss, my
The lordship is keeping for tomorrow.
When do you want?
lord. Any day that suits, my lord. But
Whenever you can get this technical objection will not hold good.
my lord may keeps it on 8 subject to my lord.
Whenever
sanction.
you want, whenever you can get the instruction.
Subject to sanction, my lord.
8th?
8.
My lord, before my lord rises, my lord.
Yes.
My lord, this filing, my lord, I mentioned it 2 times yesterday, my lord.
Yes.
Still, they are not taking the filing, my lord. I have tried since the morning, my lord. My lord,
They have not taken it? Okay. Wait. Yes.
My lord, may I be allowed to appear virtually before your lordship, my lord?
The present appeal under section 37(2) of the Arbitration and Conciliation Act is accordingly dismissed. All pending application, if any, also stands dismissed.
Grateful, lordship.
My lord, only one thing may I pray, my lord. My lord, no, my lord, to give an, my lord, stay of the operation of this order for a period of 2 weeks, so that, my lord, I can prefer an appeal.
My lord, that
Subject to
would
whatever your lordship, my lord.
Not at all.
My lord,
grateful.
only a period of 2 weeks, my lord, I'm seeking.
Not even a day.
Because, my lord, they have already come up with a contempt application before your lordship.
Very good.
So now that they will enforce it very.
Wednesday, है ना?
Bow down to you.
Grateful, lordship.
Lordship, I am for the petitioner. This is my affidavit of service, your lordship. I have served through email and by post as well. The post has come back as insufficient address. That is the address that is in their ROC as their
Application.
post.
Learned counsel for the petition seeks and is granted 2 weeks time to file 2 weeks time to serve upon the respondent through publication. The same shall be done in 2 leading newspapers, one in English and the other one in vernacular. Affidavit of service shall be filed on the next date. List on after how many?
Your lordship, 2 weeks. So
List after 3 weeks.
obliged, your lordship.
Very clear. Affidavit of service taken on record. It indicates that the respondent has not been served due to insufficient. Yes. Okay, bye.
Well, appearing for the petitioner, lordship, the affidavit of service is on record. Despite service, the respondent did not appear on the last occasion, lordship. The last order dated 26th February 2026 records the same. This is my application for appointment of an arbitrator. The dispute is arising out of a business loan agreement entered into between the parties, lordship. The agreement is dated July 30, 2024.
Just. What are the dates?
The agreement dated July 30, 2024, appearing at page 16. And the arbitration clauses are appearing at page 17, lordship, clause 9.
Page 30.
Page 16 is the agreement, starts from page 16, and the arbitration clause is at page 17. At the bottom, lordship, arbitration clause. And your lordship will find the place of arbitration to be at Calcutta at page 19, Lordship, in the schedule. At page 20, Lordship, the schedule starts from page 19, and at page 20, the place of arbitration and jurisdiction, it has been given at Kolkata, Lordship.
Okay.
Serial number 13 and 14.
Loan agreement?
Loan agreement, business loan agreement. Agreement was for 25 lakhs and odd.
Notice?
Notice, Lordship, the section 21 notice is at page 21.
Dated?
Dated 8th January 2026. This was duly delivered on 15th of January, and thereafter they did not give reply, and we filed this section.
Loan recall notice?
Loan recall notice is dated 13th December 2025, Lordship. In the pleadings, I have craved leave to produce the same 50 loan recall notice. December 2025, Lordship.
Take down. The petitioner has preferred the present application under Section 11 of the Arbitration and Conciliation Act 1996, seeking constitution of an arbitral tribunal comprising of a sole arbitrator to adjudicate the dispute between the parties. Full stop. Learned counsel for the petitioner submits that the respondent availed financial assistance from the petitioner to the tune of 2527449 under a loan agreement dated 30th/7/2024. Full stop. It is submitted that the respondent committed defaults in adhering to pay the repayment schedule. Full stop. In view thereof, the petitioner issued a loan recall notice dated 13/12/2025, calling upon the respondent to clear the outstanding dues. Full stop. Despite receipt of the said notice, the respondent failed to liquidate the outstanding dues. Full stop. Learned counsel for the petitioner further submits that the petitioner invoked the arbitration clause contained in clause 9 of the said loan agreement by issuing a notice dated 8/1/2026 under section 21 of the Arbitration and Conciliation Act 1996. Full stop. Despite receipt of the said notice, the respondent failed to respond thereto. Full stop. The dispute between the parties arises out of the alleged default in repayment of the loan amount. Full stop. The notice invoking arbitration was issued on 8/1/2026. Full stop. Prima facie, it appears that the dispute has arisen between the parties in terms of the loan agreement dated 30th/7/2024, which contains an arbitration clause, being clause number 9 thereof. Full stop. Accordingly, this court is satisfied that the present case is a fit case for reference to arbitration. Full stop. Yes. What is your name? How many years?
16 years.
Accordingly, this court appoints Mr. Jointo Sen Gupta as the sole arbitrator to adjudicate the dispute between the parties. Full stop. The learned sole arbitrator will be entitled to remuneration in terms of the fourth schedule. Full stop. All questions relating to arbitrability of the dispute, admissibility of the claims, limitation and other issues are kept open to be urged before the learned arbitrator. Full stop. The A copy of this order shall be communicated by the petitioner to the learned sole arbitrator for necessary action. Full stop. With the aforesaid direction, the present petition stands allowed. ये उसमें डाल affidavit service. उसमें एक लाइन ऊपर लिखवाना affidavit of service taken on record. Despite service, none appears for the respondent.
Lordship, the next matter is a similar matter, different party and a different respondent, Lordship. On the last occasion, they also did not appear despite service.
Just give me the amount.
There it is a working capital agreement, Lordship, loan agreement dated 31st of May 2024.
31st of May 2024. Loan agreement dated 31st of May 2024. For an amount of rupees
29,24,329. 29,24,329.
329. Loan recall notice.
Loan recall notice on 30 December 2025, Lordship. I had craved leave. This is the loan recall.
December 2025. And
Section 21 notice on 8th of January 2026 at page 22.
Rest same. And this madam, how many years she has put in? Madam, how many years of practice? Give your details. This court appoints Miss so and so as the learned souls. Baki same hai.
My application, my lord.
Yes.
My lord, the disputes pertain to a lease agreement, my lord, which had been executed. The water supply was required to be made uninterrupted by the respondent, who is the lessor, my lord, in respect of the property. The concerned clause, your lordship, my lord, the lease deed, your lordship will find at page 23, my lord, of the
Dispute
application.
is between?
I beg your pardon?
Dispute is between who?
Between the petitioner, who is the lessee, my lord, in respect of the premises, and the respondent, who is the lessor. Now, my lord, the lessor was under the lease, was required to provide uninterrupted supply of water. That had not been done. In fact, now what they are seeking to do is, my lord, is to levy a charge for supplying the water. My lord, that has been specifically provided for in the lease deed, my lord, at clause 5.4, page 31, my lord, of the application. The lease deed begins, my lord, at page 23 of my application, annexure A. And this is at page 31, my lord, clause 5.4. If I may place that, my lord.
Yes.
The lessor
dated 25th January 2020.
2020, my lord.
What are you reading?
My lord, this is the relevant clause.
53? Which one?
Page 31, my lord, clause 5.4.
5.4.
5.4, my lord.
The point is not visible. Yes.
That's because of the photocopy, perhaps, my lord. The lessor shall provide uninterrupted supply of water to the demised premises through overhead underground reservoir, and agree that they will neither do not allow anybody to do any act, omission, etc., due to which water supply at the demised premises gets suspended, disconnected. This is the sum and substance of the matter, my lord. Thereafter, my lord, the arbitration clause, my lord, your lordship will find it at page, just gives me a moment, my lord, page 38, clause 16. I'll just place it once, my lord. In case any difference or dispute arises between the parties to this lease deed in relation to any of the matter connected to this lease deed, then the parties to the lease deed must primarily attempt to get it resolved amicably through discussion. If such difference or dispute, including dispute, arises on the interpretation of any of the clauses under this agreement in regard to any of the matter connected to this agreement cannot be resolved amicably through discussion, then the same shall be referred to the mutually agreed sole arbitrator appointed for the purpose. The arbitration proceedings shall be governed by the provisions of the Arbitration and Conciliation Act 1996 as amended up to date. In the event of the decision of the sole arbitrator, shall become final and binding to the parties to the lease deed. And the venue of the arbitration shall be at Kolkata. The cost towards the fees of the sole arbitrator shall be equally borne by the parties. So this was the arbitration clause. Now the disputes arose, with regard to supply of water. There are plethora of correspondences which had been exchanged between the parties, which would appear at pages 41. Thereafter, the response thereto at page 43, where they had been raising invoices. Now, eventually, pursuant to this, the section 21 notice, was issued on 27th of November, which your lordship will find at page 66 of my application. 27th November 2025, where we had indicated, at page 69, we are at clause 25, paragraph 25, that our client had approached you on several occasions for the purpose of having the uninterrupted water supply restored to the subject property, but you failed and neglected to do so. In fact, in paragraph 27, does in terms of the aforesaid clause, all discussions to amicably resolve the dispute has failed because there had been several correspondences exchanged which did not fructify. This was delivered on the respondent at page 71. The notice under section 21 was delivered on 28th of November. At page 71 is the delivery report. At page 72, is their response. Where they initially say, that the dispute is not arbitrable, but thereafter they have acknowledged that there exists a dispute pertaining to supply of water. The third paragraph of at page 73, there having several correspondences in between my said client and your client as to the alleged water dispute, whereby it has been clarified that there is no provision for adequate water supply in the leased out premises and your said client is to bear the water charges for consuming water, to which your said client had agreed but do not pay any water charges to the society of flat owners. So this is the dispute, the sum and substance of the dispute. So all that I'm seeking, at this juncture is let a sole arbitrator be appointed, because under the lease deed itself, the obligation was on the respondent as the lessor, to provide uninterrupted water supply to the lessee, which is the petitioner before your lordship, for which they are now seeking to levy charges.
Yes, my lord. My prayer before your lordship is this, that though there is a specific mention, the venue should be in Kolkata, but my lord, the venue is Kolkata, the sitting place might be in Asansol, my lord, because the dispute is in Asansol and my client, though husband and wife only, they are suffering from different ailments and aged also. They have their very big network, my lord. They are corporate world. They have enormous network.
We go with the law, sir. We don't go by big and small.
But my lord, only thing is this, accepting it, I can't say anything before your lordship right now.
Except for the appointment of the arbitrator, you have already mentioned the seat in Calcutta.
Yes, my lord,
Everything is
what I would have
Calcutta.
submitted, my lord.
So it is, venue has been specified, my lord, but if your lordship kindly give us the leave to sit in Calcutta, Asansol, it will be better for everyone, my lord. Property is in Asansol, dispute there is in Asansol.
You have chosen I can't change the terms of the contract. What argument are you making?
Wait.
What argument are you making? Can it be done? You tell me, you're a lawyer.
My lord, always court has his inherent power, my lord.
Inherent power in a contractual dispute to change the terms of the contract.
And the circumstance is this, my lord. Both of them, husband and wife, are very aged, my lord. They are unable to come to.
They'll appoint you the way you are coming here today. The same way you continue to be appointed.
They have enormous network, my lord.
So, enormous network, so they have no right.
They have always opportunity to sit there in Asansol, my lord, but it is very tough for my
Why,
client.
why did you agree?
That is the fault, my lord. Always arbitration clauses, big concerns are creating such type of
Shouldn't have
clauses.
given, property is yours. Your property, right? You have given for free. You're not charging. You're not getting rent.
And the dispute is
What arguments are you, sir? What
here.
are you?
Leave it to law.
Take down. The present application has been filed under Section 11 of the Arbitration and Conciliation Act 1996, seeking appointment of an arbitrator for adjudication of the dispute between the parties arising out of a lease agreement dated 25/1/2020. Full stop. Learned counsel, Mr. Banerjee.
Sengupta, my lord.
Mr. Sengupta. Learned counsel, Mr. Sengupta, appearing for the petitioner, submits that the parties entered into a lease agreement and the respondent, being the lessor in respect of ground floor and first floor of the premises, being Apar Garden, Anand Apartment, 190 GT Road, West, Asansol, 713304, had leased out the said property to the petitioner herein. Full stop. It is submitted that the lease deed was executed for a period of 9 years, commencing from 15 January 2020 and continuing until 14th January 2029 for the purpose of running a diagnostic and medical center. Full stop. Learned counsel for the petitioner submits that under clause 5.4 of the lease agreement, the respondent was under an obligation to provide uninterrupted water supply to the petitioner. Full stop. However, the respondent allegedly failed to fulfill such obligation and the water supply to the leased premises was interrupted. Full stop. It is contended that the interruption in water supply arose due to disputes regarding payment of water bill between the respondent and the Anand Apartment Flat Owners Association, which ultimately led to disconnection of the water connection. Full stop. Although the water connection was restored, subsequently, such interruption allegedly caused substantial disruption to the functioning of the petitioner's diagnostic center. Full stop. Learned counsel for the petitioner further submits that in terms of clause 16 of the lease agreement, and he submits that the clause 16 of the agreement contains a lease clause, arbitration clause, providing for resolution of disputes through arbitration by a sole arbitrator with the seat of arbitration at Calcutta. Full stop. It is submitted that in view of the dispute that arose between the parties concerning the supply of water, the petitioner had earlier approached the commercial court at Asansol by filing an application under Section 9 of the Arbitration and Conciliation Act, being commercial case number 13 of 2025. Full stop. By an order dated 4th September 2025, the said court had granted interim order restraining the respondent from withholding water supply to the leased premises. Subsequently, a notice under Section 21 of the Arbitration and Conciliation Act, invoking the arbitration clause contained contained in arbitration clause number 9, dated 27th November 2025, nominating Honorable Justice Ranjit Bagh retired as the sole arbitrator was issued. Full stop. It is submitted that upon receipt of the said notice, comma, the respondent by a letter dated 29 December 2025 denied the existence of any dispute between the parties and refused to refer the matter to arbitration. Full stop. Though the letter admits that it was incumbent upon the respondent to supply the water uninterruptedly. Full stop. Learned counsel for the respondent states that the dispute is arbitrable. He does not deny the existence of an arbitration clause under the lease agreement, but raises the grievance only to the extent that the petitioners, the respondents being aged people and residing at Asansol, would prefer the arbitration to be conducted at Asansol. Full stop. This court cannot modify the terms of the contract. Full stop. In view of the fact that the respondent had refused to refer the matter to arbitration, the petitioner has filed the present application under Section 11, seeking appointment of an arbitrator. Having considered the submissions made by the learned counsel for the parties and upon perusal of the materials placed on record, it appears that existence of an arbitration agreement between the parties is not in dispute. The parties have also admitted to an existence of an arbitration agreement. Full stop. The dispute arising out of the lease agreement are prima facie arbitrable. Full stop. In such circumstances, and in view of the failure of the parties to mutually constitute the arbitral tribunal, this court deems it appropriate to exercise its power under Section 11 of the Arbitration and Conciliation Act and appoints Mr. Satadaru. I'll appoint you here, learned senior counsel, Mr. Just give Satadaru as the arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall make disclosures in terms of Section 12 of the Arbitration and Conciliation Act. The remuneration shall be fixed in terms of fourth schedule of the Act. A copy of this order shall be communicated to the learned sole arbitrator to take necessary action. With the aforesaid direction, the present petition stands disposed of.
My lord, the affidavit of service, my lord, may be taken on record.
Affidavit of service taken on.
Grateful. Deeply obliged.
I'm for the petition. My affidavit of service. This is an application for appointment of arbitrator arising out of a dealership agreement, which was Annexure A, my lord.
Page?
Annexure A starts at page.
My lord, challenging the maintenance.
Page 12.
We have already preferred an application challenging the maintainability of this arbitration agreement, and that is duly served, but due to technical glitches, we could not upload this.
You could not upload this?
So all are ready.
Upload where?
Upload in the portal.
What portal? Which portal?
The original site portal है
Hmm?
uploaded.
Malord, if-
This is your reply to the application?
No. They have filed an application. May I say? After service of the application under section 11, they have filed an interlocutory application stating that this application is not maintainable. On the ground, since the husband has expired, the dealership agreement was executed by the husband. The petitioner number 1 is the wife of the actual stockist, my lord, and the petitioner number 2 and 3 are the daughters, major daughters, my lord. If my lord turns to page 12, annexure A.
How can the wife be made a party?
My lord,
Which is the agreement?
My lord,
The initial agreement is between
the husband. It includes, the terms includes.
Show me.
My lord,
How can you make the wife a party? How is this arbitrable?
my lord, page 12. If my lord comes to
Read
annex,
it. I'm reading it.
my lord.
Yes.
This is the agreement between Shalimar Pellet Feeds Private Limited, Shalimar Pellet Feeds Limited, a company incorporated, and Samir Kumar De, son of such and such, a proprietorship business of poultry, 5-star poultry feed center, having his place of business at such and such, as the dealer stockist of the second part, which term expressions are unless excluded by the repugnant to the context, that include the said proprietors and their heirs, successors, legal representatives, assigns of the other part, my lord. The term second part is the original dealer who was appointed for the distributing the materials in Krishnanagar, in the district of Krishnanagar. My lord, in the meantime, he made a payment. The check was issued. My lord, if my lord turns to page.
Has she signed the agreement?
No, the husband signed the agreement during his lifetime. The husband signed the agreement.
Very good. Not maintainable. Yes. Go further.
The husband signed the agreement, my lord. Page 14. And the
Yes.
page 14 is the signature part, my lord. First part is the company and the second part is Somor Kumar De.
Very good.
The term second party includes the legal heirs. The legal, there's a claim of rupees 59 lakhs and odd. But a check was issued of 95 lakhs. My lord, if my lord takes the page 19 of my application.
Yes.
The check was issued by the husband during his lifetime.
Yes.
For a sum of rupees 93 lakhs 51,434. That was dishonored, and after that some payments were made. Today the outstanding dues is rupees 59 lakhs for 51,434.
Yes.
It's a proprietorship business. They are the husband expired. The petitioner is the legal. The petitioner
Husband expired, so wife will have to pay.
Wife, they are bound by this agreement, my lord. They are bound.
She has signed the agreement.
She never signed the agreement, but the husband
is still bound by the agreement.
But the term includes the term. The term includes, my lord. If my lord takes up once again the term, the second party.
I have seen it. Second party.
That the term includes the second party. Includes the heirs, legal heirs, representatives, and assigns.
What else?
Well, this is the main thing.
All right, take down. You have to say something.
These are within our grounds, my lord. These are the
Keep your grounds to yourself. Take down. The petitioner has preferred the present application under section 11 of the Arbitration and Conciliation Act 1996, seeking appointment of an arbitrator for adjudication of the dispute between the parties. Full stop. Learned counsel for the petitioner submits that the petitioner is engaged in the business of manufacturing poultry feeds and carries on such business across various parts of India by appointing dealers in different states for sale of its products. It is submitted that Samir Kumar De, bracket pe karna, since deceased, bracket close, Kumar De, D-E-Y, bracket close, was appointed as a dealer for the sale of poultry feeds of the brands inverted comma mein Total and Total Eco. ठीक है, inverted total, inverted comma, and then Total Eco, inverted comma. Brands है Total, ये Total and Total Eco, ये. ठीक है ना? Along with other similar products manufactured by the petitioner in the district of Nadia by virtue of an agreement dated 7th December 2015. Learned counsel for the petitioner contends that during the course of the business transaction between the parties for the period from 1st April 2015 to 2nd May 2025, a sum of rupees 5,951,434 allegedly became due and payable by the said dealer to the petitioner. Full stop. Petitioner approached the respondents, who are stated to be legal heirs of the said deceased. Full stop. Said deceased, namely respondent number 1 being the widow and respondent number 2 and 3 being the children of late Samir Kumar De, seeking repayment of the alleged outstanding dues. According to the petitioner,
If my lord takes up the definition
Can you-
of legal representative
can you-
and section 40,
can you hear the order, sir? Take it in appeal. And somebody is dictating the order, don't disturb. क्या लिखा है?
Petitioner approached the respondent, who was stated to be the legal heirs of the said deceased, namely respondent number 1 being widow
Widow.
and respondent numbers 2 and 3 being children of late Samir Kumar De,
Yes.
seeking repayment of the alleged outstanding dues.
According to the petitioner, the respondent denied their liability to repay the said amount. Full stop.
my lord,
Consequently,
may I interrupt once, my lord?
sir, you please hear me out.
Section 21 reply,
Observe.
they have not given the reply to this. These points were not taken up in the section 21, my lord. I'm sorry,
Dismissed. I'll pass the order in the chamber. Next.
I'm sorry, my lord, if my lord,
Dismissed. I'll pass the order in the chamber. Take it down. At the time of dictating the order, learned counsel for the petitioner started interrupting. This court refrains from passing the order and will pass the order in the chamber. The present petition stands dismissed. Reasons to follow. Next. What is your name?
my name,
Yes.
Pawan Kumar Bora, my lord.
उसमें लिखवाओ 2 लाइन और लिखवाओ. Hey, Riya. This kind of a practice is completely learned counsel. Mr. Ayan Kumar Bora is warned from carrying out this kind of practice, which is deprecated by this court, and this court will be compelled to take necessary action if the same is repeated on the next occasion. Next.
I'm sorry, my lord, but I was just
Due
saying,
to the unconditional apology tendered by the petitioner, this court refrains from making any further statements against the counsel. The counsel. Don't do that.
no, my lord, that's not, I was just saying that the, under section 21,
Have you heard my? Did you hear it out?
no, I was hearing out.
Did you hear the order? How do you know what I will dictate?
I'm sorry, my lord. If my lord dictates the order, I would be bowed down by that thing, my lord.
How do you know? Privity of contract. You take it wherever you have to. If a legal heir can be bound, that is your opinion. And all orders are subject to challenge. You challenge it. I'm of that opinion.
That I bow down, my lord. But
Then-
the Arbitration Act section 40 says that,
Sir, you challenge my order.
my lord would
I'm not concerned.
no, I'm not. My lord, pass the order, pass necessary orders, my lord.
When an order is being dictated, how can you interfere in between?
My lord, I'm sorry, my lord. Sorry.
I've allowed you to make your submissions. I'm not even cutting short.
No, my lord. I bow down for that.
Then you start interjecting. What kind of practice is this?
No. I was just in the point that when the section.
All orders are subject to challenge.
Yes, ma'am.
That's my opinion.
I bow down that.
I'll pass an order. Next. Take down next. Next, I'll pass an order. I've lost my thought. Next. Well, dismissed. I'll pass an order. Reasons I'll give later. Disposal, dismissed. Next. Reserve nahi hoga, dismissed. I'll give the reasons. Next.
16.
I appear for the
I
respondent.
am for the petitioner, sir. Sir,
Yes.
Lordship, I am praying for an adjournment, Lordship.
Why?
The learned counsel on behalf of petitioner, she is having fever, so she can't appear.
Proxy counsel so and so appears and states. Any objection?
No.
States that the main arguing counsel is indisposed. He prays for an adjournment. Let this matter be adjourned to.
Although I was agreeable for the appointment, so any lordship keeps it at any time on Monday, Tuesday.
Next week, my lord.
Next week?
Yes.
When?
Any day next week, my lord. Monday, Tuesday.
Gopal, next date दे दो. कब का है? Monday? Next Monday. Next.
Much of
Great.
much of
वो उसमें सब कुछ
सब कुछ जो पहले से हुआ
complete. Then I'll give the reasons. You just give me the typed one. I'll give the reasons.
Indeed.
17, I beg to appear for the petitioner, my lord.
I am for the respondent, Indian Corporation Limited.
My lord, it's an application for appointment of the arbitrator. My lord, the petitioner was appointed as the dealer for the retail outlet in the district of Kuch Bihar, my lord. My lord, the petitioner, thereafter there was a show cause notice and reply to show cause notice was given, and thereafter they have passed an order of termination on the ground that there is a malpractice on the part of the petitioner with the dispensing unit. I mean, dispensing unit is the machine from where the, my lord, the oil is given to the vehicles. My lord, that termination notice was challenged in a writ petition, my lord, that was taken up to Supreme Court and it was rejected, my lord. Thereafter, my lord, the section 21 was invoked. They have replied to that section 21, my lord. Now I am before your lordship paying for an appointment of an arbitrator, my lord. Now, if my lord, if I take your lordship to the agreement, my lord, the agreement starts at page number 17 and the arbitration clause is at page number 41, my lord. Clause 62A. That the arbitration agreement, if I may read it for you, lord. Page 41, my lord. I'm sorry. May I read it for you, lord?
Yeah.
Any 62A, any dispute or difference of any nature whatsoever, any claim, cross-claim, counter-claim, or set-off, or regarding any right, liability, act, omission, or account of any of the parties hereto arising out of or in relation to this agreement shall be referred to the sole arbitration of the director marketing of the corporation, who may either himself act as the arbitrator or nominate some other officer of the corporation to act as the arbitrator. The dealer will not be entitled to raise any objection to any such arbitrator on the ground that the arbitrator is an officer of the corporation. Next, my lord, in the event of the arbitrator to whom the matter is originally referred being transferred, he shall be entitled to continue the arbitration proceeding notwithstanding his transfer, unless the director marketing at the time of such transfer or at any time thereafter designate another person to act as arbitrator in his place in accordance with the terms of this agreement. C. In the event of the arbitrator to whom the matter is originally referred, vacating of his office or being unable or refusing to act or for any reason, the director marketing at the time of vacation of office or inability or refusal to act shall designate another person to act as the arbitrator in accordance with the terms of this agreement. D. The arbitrator newly nominated by the director under clause B or under clause C above shall be entitled to proceed with the reference from the point at which it was left by the predecessor. E, it is an express term of this contract that no person other than the director, marketing, or person nominated by such director of the corporation as aforesaid shall act as arbitrator hereunder if for any reason director marketing is unable or unwilling or refuse or fails to act as the arbitrator or nominate an arbitrator, then the matter shall not be referred to arbitration at all. The award of the award of the arbitrator so appointed shall be final, conclusive, and binding on all parties to the agreement, subject to provision of Arbitration Act 1940 or any statutory modification or reenactment thereof, and the rules made thereunder for the time being in force shall apply to the arbitration proceeding under this clause. G, the award shall be made in writing, published by the arbitrator within 2 years after entering upon the reference, or within such extended time not exceeding 1 further year as the party shall be willing to agree. The parties here to make be deemed to have irrevocably given their consent to the arbitrator to make and publish the award within the period referred to herein above, and shall not be entitled to raise any objection or protest hereto under any circumstances whatsoever. H, the arbitrator shall have power to order, direct, and either of the parties to abide by, observe, and perform all such direction as the arbitrator may think fit, having regards to the matter differences that is dispute before him.
Lord, may I make it this matter shorter? There is arbitration clause. The dispute regarding his tampering with the dispensing unit, this comes under the marketing discipline guideline. That point can be can be kept open with the arbitrator. All the disputes regarding this limitation and the other points, because he has challenged my termination letter. And in the writ proceeding as well as in the appellate proceeding before the Honorable Supreme Court, there are dispute arose whether his termination comes under the provision of marketing discipline guideline or not. So, if marketing discipline guideline comes, there is a provision of appeal as per the marketing discipline guideline. He ought to file appeal before the appellate authority. Instead, he came with the arbitration clause. Those points can be kept open.
The arbitrator, my lord, he is now asking the jurisdiction of the arbitrator. Let the arbitrator take decision on that. If my lord be pleased enough, arbitrator
As
be
well as
appointed.
limitation. As well as
It's always
will be left open to
yes,
the
my lord.
arbitrator.
That's settled. My lord. He can take those points before the arbitrator, my lord.
Both of you agree, then I'll appoint an
My
arbitrator.
lord, kindly, madam. This is my prayer.
Kindly make an order of court.
Oh.
Give me the dates.
My lord. My lord, the agreement is
Agreement is
agreement is it's page 17. My lord, it is dated 29th November 2021.
termination.
Termination is at, my lord, 24th January 2023, my lord.
24th January 2023.
2023, my lord.
You challenged it?
Yes, my lord, I have challenged it before the Honorable Writ Court.
Where's the order?
My lord, it is at page number 91. WPA 347 of 2023, my lord. Which was dismissed on 27 November 2024, my lord.
27 November.
November, my lord. And thereafter, it was taken up in appeal, my lord, which was also dismissed on 25th April 2025. The page is at 104, my lord.
104.
Sorry, 109. I apologize, my lord. 109.
Then you went all
the
way up.
All the way up, my lord. It is at page number 122. By the order dated 4th September 2025, the SLP was dismissed, my lord.
Thereafter, my lord, they have also prepared an application under section 9
Page?
of the arbitration.
Page?
My lord, page 122, the order of the Honorable Supreme Court, my lord.
Yes, then what happened?
Then, my lord, in the month of December, page 123, I have sent a notice under section 21 on 6th of December 2025, and that starts at page number 123, and at page number 131, they have replied to that notice on 5th of January 2026, my lord. Page 131, my lord.
150?
131.
130.
The last page, my
Reply.
lord. That is their reply to my notice under section 21.
Okay. Then what happened?
Then, my lord, I have came before your lordship, my lord. Taking
Yeah.
for an appointment.
Also, they have filed an application under section 9 before the learned Jalpaiguri court, Siliguri court. That application was rejected as the jurisdiction doesn't, the agreement doesn't confer jurisdiction in that court. So that has been rejected or given.
He has come to the
That
right.
is not been annexed here.
But that's all right. He's in the right court today.
Yes, that is section 11 is the right court. Section 9 they have preferred.
Here, my
they have-
prayer is only for
they have,
appointment.
they have not annexed with their application.
Take down. The petitioner has preferred the present arbitration petition has been filed under section 11 of the Arbitration and Conciliation Act 1996, seeking appointment of a sole arbitrator to adjudicate the dispute between the parties. The petitioner was appointed as a non-exclusive dealer of the respondent for the retail sale and supply of petrol, HSD, motor oil, at Madhya Kashyabari PO, Haldibari. ठीक है District Cooch Behar, pursuant to retail dealership agreement dated 29/11/2021 executed between the parties. Subsequently, dispute arose between the parties and the respondent, by a termination letter dated 24/1/2023, terminated the said dealership agreement. Being aggrieved, thereby the petitioner filed WPA 347 of 2003 before the circuit bench of this court at Jalpaiguri. Full stop. The said you challenge that order, right?
My lord.
That order was challenged.
Yes, my lord. The order was challenged in the writ court, my lord.
This
Page
court
109.
This court by order dated 27/11/2024 disposed of the writ petition as not being maintainable. And thus it was dismissed. Full stop. The said order was taken in appeal in MAT number 109 of 2024. The division bench of this court, while its order dated 25/4/2025, what happened in the DV?
My lord.
What had happened in MAT?
MAT was also, my lord, dismissed, my lord.
Uh,
It was the order of the single bench was not interfered with, my lord.
The division bench did not of this court, while order dated 4/2025, did not interfere with the order of the writ court. Full stop. The petitioner unsuccessfully challenged the same before the order of the division bench was unsuccessfully challenged before the Honorable Supreme Court. Full stop. The special leave petition preferred by the petitioner came to be dismissed by order dated
4th of September 2024.
4/9/2025. Full stop. Thereafter, the petitioner, by notice dated 6/12/2025, invoked the arbitration clause contained in clause 52A of the agreement in terms of section 21 of the Arbitration and Conciliation Act 1996 and proposed the name of Mr. Biplav Ghosh to act as the sole arbitrator. Full stop. The respondent, by letter dated
5th January.
5th January 2026, right?
My lord.
2026, did not consent to the said appointment, compelling the petitioner to approach this court by way of section 11 petition for appointment of an arbitrator. Learned counsel for the respondent does admit to the existence of the agreement and that and does not dispute clause 52A of the said agreement. Full stop. This court note 52 or
62A.
Sorry, 62A. This court notes that 62A, sorry, not 52A, 62A. This court notes that 62A of the agreement provides for appointment of an arbitrator by one of the parties. Full stop. However, the law is now settled that unilateral appointment of an arbitrator by an interested party is impermissible. Full stop. At this stage of exercising jurisdiction under section 11 of the Act, exercising jurisdiction under section 11 of the Act, this court is only required to examine the prima facie existence of an arbitration agreement. Full stop. Having considered the materials placed on record and the submissions advanced by the parties, wherein the arbitration agreement is not in dispute, this court is satisfied that the parties can be referred to arbitration. Full stop. Since the parties have failed to constitute the arbitral tribunal in accordance with the procedure, this court considers it appropriate to exercise its jurisdiction under section 11 of the Arbitration and Conciliation Act 1996. Full stop. Accordingly, Mr. Who is here? How many years you have put in? Yes. Or is too less? Accordingly appoints, I'll give a name. Nobody senior. Nobody senior here. Where?
Dashgupta is here, my lord.
Hey, why are you hiding? Huh? Sorry. Why are you hiding? Appoint Mr. Saurajit Das Gupta as the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. And don't come seeking an extension. This
Lordship may provide
the-
and not grant any unnecessary adjournments. That will suffice.
the parties shall not take any unnecessary adjournments before the learned arbitrator. Full stop. The party undertakes not to take unnecessary adjournments before the learned arbitrator. Full stop. The learned arbitrator shall fix his remuneration in terms of fourth schedule of the Act. Full stop. Adequate declaration under section 12 shall be made by the learned sole arbitrator. Full stop. A copy of this order shall be communicated. Parties shall communicate a copy of this order to the learned sole arbitrator to take necessary action. With the aforesaid direction, the present petition stands disposed of.
Lordship, all the questions relating
All issues regarding arbitrability, limitation, or any other issue shall remain open to be adjudicated by the learned sole arbitrator.
Grateful, Lordship.
Grateful, Lordship.
Grateful.
My lord, be the service, affidavit service be taken.
Affidavit of service taken. Non-commercial.
Let the next matter have instructions to withdraw.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. After seeing you, people withdraw. Use the same force, finish off the arbitration in time.
The email may be kept on record.
Copy of the instruction received from the client to withdraw the
first email. Yes.
The petition is taken on record.
But
From the client to withdraw the petition is taken on record. Dismissed as withdrawn.
for our purpose, will your lordship record my submission that all allegations made in the application are denied?
Goes without saying.
If your lordship, but for our purpose, it is not required, my lord. Even I know.
Why should I?
Right. Great.
My lord, in item number 1, I pray to appear on behalf of the petitioner herein. Am I audible, lordship? My lord, am I audible? My lord, am I audible, my lord? Lordship, am I audible? I am appearing for the petition in the item number 1, my lord. And this is an application for restoration of the section 11 application. There had been a delay of 62 days in filing, and as such, a petition has been filed for condonation of delay.
Today there's some problem.
Your lordship is audible, but am I audible, my lord?
क्यों? अच्छा भाई इसको हटा दो, अभी सुनाई तो दे रहा था, ऑडियो को हटाओ.
Am I audible, my lord?
Who's appearing on the other side?
Lordship,
Same.
no, I'm not sure who is appearing on the other side. This is for restoration, my lord. The petition was dismissed for default, and there has been a delay of 62 days in filing
Not
the
today.
restoration, my lord,
Not
and
today.
as such,
I can't hear you.
my lord kindly keeps the matter next week. I'll What is happening? What is happening? My audio is open. My lord, am I audible now? Am I audible now, my lord?
3 and 4, my lord. 3 with 4, yes.
My lord, this matter was last taken up on the 25th of February when
My affidavit.
pleadings were complete in their 29A, where I'm not opposing extension of time, but I'm praying for a replacement of the arbitrator. Now, I'm only opposing it to that extent. Now, we also preferred, my lord, a section 14 and 15 for that purpose, and that was tagged along with the 29A. Now, my lord, yesterday, although there were no directions for exchange of affidavits in the 14 and 15, yesterday, my lord, they have served upon us an affidavit in, my lord, opposition. My lord, if your lordship is, my lord, agreeing to, my lord, take that on record, because no directions were given in the 14.
We'll take it.
Then in that event, my lord, I'll have to put in a reply. Or if your lordship decides, my lord, to not, my lord, take
No,
this
no,
one.
take
board.
it. I have to take it. How can I not take it?
No, because my 14, I'll be candid. My 14 is essentially same as my opposition to the 29A, and they've put in a reply to that.
You said, my lord, landed arbitrator is de facto incapable.
You have to understand.
Incapable.
Yes.
Mr.
Yeah,
Lakhani,
Yes,
I have
my
to
lord.
respond to this.
I have limitations in 29A. I have to deal with 14.
Yes.
Or I can't change an arbitrator, substitute an arbitrator in 29A. So
Understand,
your
my lord.
reply will not be helpful for. His reply will not be helpful
Very.
for.
In that event, my lord, kindly.
I have to take the
Understand.
pleadings have to be completed so that I can pass an appropriate order.
So in that event, my because, my lord, my property is held up. We are actually in the hurry to, my lord, have this.
I have initiated with they are not. They are in a hurry.
No, my lord, we are in a hurry.
They have filed. Go before the arbitrator.
No, I will go some other arbitrator. my lord. I'll satisfy your lordship. This now after
they have taken
after this application having been filed, I cannot go back to that arbitrator. And your lordship has, my lord, video recording in the courtroom, and there's no chance I can go back.
that is a ground for my lord. Substitution. Very good ground.
I will inevitably, my lord, suffer.
If that will be a ground, then everybody, it will become very difficult for anybody to function,
Yes.
even for judges.
Yes.
My lord, at least, my lord, when I would
Then,
request
my lord,
that
it
on the day of argument, my
would
lord,
be
your
very
lordship would
difficult to remand.
No, Lord.
Remand.
on the day of argument, my lord, your lordship would
We are
consider.
all above this. No criticism,
No, understandable. My lord,
statements.
Yeah,
no.
exactly.
on the day of the
These are things which doesn't matter.
no, but on the day of the argument, I'm hoping, my lord, your lordship will just suspend the video for a little while. 15 minutes only.
Learned counsel for the which item is that 4 is your 1450, third is what? Third is 29.
Third is
Yes.
29, yes.
Their
All right.
affidavits are
Then
complete.
everything is
No, no.
complete.
Today I'm going to file
Yeah, you put in your
reply.
You're filing a reply, right?
Reply, yes.
Just give it. Affidavit. Affidavit in reply to the affidavit in opposition filed by the respondent is taken on record. This is an item 3. Item 4. Item 4 would be learned counsel for the you're filing. This is you're
Yes.
filing in 3
Petition, my lord, today.
opposition in 3, right? 29A.
No, in 14 and 15.
So this is
in
item
29A, 3, he's filed his reply.
Reply.
Now in 4, he's filing his opposition because 4 is my application.
Where's your reply?
Yes.
So this is it.
14, 14 and 15.
This is 14.
Number 4.
Okay, madam. That's what. So item 4 is AP 34.
Yes, that is my application where he's putting in his opposition.
All right. So AP 34, which is number 4. उसमें डालो नहीं item number AP 34 is item number 4. All right. So affidavit in opposition filed by the respondent is taken on record. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the said affidavit in opposition. ये हो गया 4 में. All right. Item 3 में था affidavit is taken on. Both after when do you want? After 3 weeks?
Yes, my lord.
Yes.
Would your lordship be pleased to fix any date?
तो ये नॉन कमर्शियल है ना किस दिन ट्यूसडे है नॉन कमर्शियल ना 21st
21st. Shupya? 21st. my lord.
21st
Yes.
21st both.
If I can, my lord, convince your lordship on the fee aspect, I may not have to go into the other issues because the arbitrator has fixed his own fee. He is not going by the schedule.
With
So I have
consent
a,
of the parties.
no, not with
Yes,
consent, not
yes.
with consent.
The
I will
bench
show that.
committee- The first meeting it was.
I'll show that, Your Lordship. There's no
I'll show.
consent. Very good.
Not today.
For the respondent.
Petitioner, Your Lordship had issued directions for exchange of
Slightly out of
affidavits.
time, my affidavit in opposition is ready, my lord. I can hand over a copy to my learned friend right now.
It gives me 2 weeks time to put in a reply.
Affidavit in.
May it be your lordship's pleasure to convert this petition into a commercial on the commercial side, because the claim is more than 50 lakhs. I don't think so. My learned friend will have any disagreement with this.
Take it up in the commercial division as well. I don't dispute that. It can be.
It is eligible to be put in
Eligible,
the-
eligible.
Learned counsel for the parties submit that the claim is more than 50 lakhs.
More than 50 lakhs. More
And-
than 50. 50.
50, right?
50.
50 lakhs. And state that the matter should be taken on the commercial side. Full stop.
Like I agreed, my lord, I hope he agrees and the mandate is extended.
I have only a point of jurisdiction.
The registry is directed to renumber the petition on the commercial side. Needful shall be done within 2 weeks. Full stop. Learned counsel for the petitioner seeks and is granted.
It's ready.
You're filing it. No, you're filing affidavit in opposition.
Opposition, my lord.
You're the respondent.
I'm the respondent.
Respondent files his affidavit. Files his affidavit in opposition. Reply to the same, if any.
2 weeks.
Learned counsel for the petitioner seeks and is granted 2 weeks time to file a reply to the same. List after 4 weeks.
My lord, anytime convenient to the bench, my lord. After 2 weeks, my lord, any day.
After 4 weeks. Give a date. In the commercial. Keep it in the commercial division. Commercial division.
Very.
Why this
My-
opposition?
My only objection is it's not a 2-1 court. The 29A.
As a prior 29A application, my lord, seat of the arbitration is within jurisdiction. Even otherwise, I will satisfy that it is, my lord, the principal civil court. Going by the, my lord, judgments, BGS, SOMA and all, those judgments.
I'll show
So
that
it is,
the
my lord,
forum selection
This is
clause
the seat
parties have.
court, I will, my lord, establish that.
I'll show that, my lord, the forum selection.
Wasting your time on this.
Forum selection clause clearly indicates
He wants
that
me to go to my lord Asansol. He never took this point when the previous 29A application was filed. He consented, my lord. I am not saying that by consent I will confer jurisdiction to a court or the court which otherwise does not have jurisdiction will get. But my lord, even otherwise, my lord, because this point may come in future also in other matters, might as well be tested, my lord. And in the meantime, there has been one more development. My lord, I have, my lord, as in my client had offered that we will let go of the interest claim because they were fighting another litigation, SAIL was fighting another litigation which has gone up to the Supreme Court, they lost. The result is that the defense they had in this litigation, that defense no longer survives. So, my lord, I thought that I will give them this offer and they are, my lord, taking a call on this offer. I have let go of the interest if the principal
I'm
is
waiting
paid.
for my client's instruction.
So, he is waiting for his client. So, my lord will come back by 4 weeks. It may so happen that the dispute
Then I
itself
don't
is...
have to do this
Yes.
academic exercise.
Yes. So we'll come back, my lord. Grateful, man.
Grateful, man. I have served a copy, my lord. Let that be recorded.
Yes, I have.
Lord, we have objection.
Lordship, in this matter, I am appearing on behalf of the petitioner and my affidavit of service and notice of motion. I'll keep it on record. It has already been served up on the other side.
Service complete?
Yes, Your Lordship. The service has already been effected.
Yes.
On 4th November 2022, by virtue of
29A application, right?
29
When
application.
was the arbitrator appointed?
The arbitrator was appointed, Your Lordship, on 4th November 2022, Your Lordship. Then the first sitting was held on 28th February 2023.
Readings completed. Readings were completed on.
Readings were completed on, Your Lordship, in the month of July 2024. Then the mandate was extended on 23rd July 2024 for the 6 months. The learned arbitrator has extended the mandate, and the entire arbitral proceeding was concluded on 20th September 2024. Then, Your Lordship, we have filed the mandate we have filed the 29A application for the first time in the 2025. By virtue of the order dated 26 June 2025, this Honorable Court was pleased to extend the mandate. The order is in the page number 25, Your Lordship. Kindly come at the page number 25. That is the first time here. By virtue of this order, this Honorable Court has extended the mandate for 4 months. Yes. Your Lordship, in this meantime, the learned arbitrator, due to some personal difficulties, has not able to communicate the order.
What is the stage?
Stage, Your Lordship, I was being communicated by the arbitrator that order has already been dictated. It is subject to communicated to us.
Only publication of.
This is only publication of the minutes. And this time the mandate was expired on 30th October 2025.
It is Mr. Satru Banerjee.
Satru Banerjee.
Very good. Why is it not passing orders?
Probably for considering some voluminous documents in this arbitration, I believe so.
Take down the petitioner. Has preferred the present petition under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for conclusion of the arbitral proceeding for publication of the court. Full stop. This court, by order dated 4/11/2022, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 28/7/2022. 28/7/2023. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended further for a period of 6 months. The first extension was given by this court by order dated 26 June 2025 for a period of 4 months. Full stop. Learned counsel for the petitioner submits that the matter is listed for publication of the award. Full stop. Considering the advanced stage of the arbitration proceeding, this court is upon consideration of materials placed on record and the argument advanced by the counsel for the petitioner, this court is satisfied that there is no delay attributable to the learned sole arbitrator in conducting the proceedings. Full stop. Considering the advanced stage of the arbitration, this court is inclined to extend the mandate of the arbitral tribunal for a period of how much time? 2 months?
2 months, maximum.
To enable the 2 months from today to enable the arbitrator to publish the award. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to publish the award within the extended time period without seeking any further extension. With the aforesaid direction, the present petition stands disposed of.
Deeply obliged.
Affidavit of service taken under call. Yes.
Well, the matter was referred to mediation, my lord, and it has been settled between the parties, my lord.
Very nice. Do you have the terms of settlement or anything?
Yes, my lord.
The terms of settlement is there?
In the mediation report.
Your Lordship, the mediation report was based on an agreement between the parties. I'm carrying a Xerox copy of the agreement, if Your Lordship.
All right.
Mediation report.
Report. The petition was referred to this court by order dated 11th December 2025 had referred the present petition for mediation. Full stop. Report has been received by the registrar, original site. Full stop. The report indicates that the parties have settled the matter. Full stop. In view of the same, nothing survives in the present petition. The parties are directed to abide by the terms of the mediation settlement.
Your Lordship, the settlement amount has also been paid to the.
The party shall act in accordance with the terms of the settlement of the
Yes, Your Lordship.
mediation. Full stop. The present petition stands disposed of.
Regarding item number 9, settlement talks processing, my lord.
You are for the
It is
petition?
I am the petitioner. It is adjourned for fortnight or after 20.
Where's the other side?
Other side not appeared.
Learned counsel for the petitioner states that the settlement talks are underway. He prays for an adjournment. Let this matter be listed after 6 weeks. Give after 6 weeks.
After
6 weeks.
not my
When do you want?
20. After
When do you
20,
want?
any day.
After 20th, it will be settled. No? 20. Give on 22nd.
Okay.
21st, sir. 21st.
In this matter, Mrs. Devjani Sen, please appear.
My lord, I am appearing virtually, Lordship. Let me to appear virtually, Lordship. In this matter, it was my section 11. Honorable Justice Shambhashaka was pleased to appoint learned senior advocate Mr. Probal Mukherjee as the learned arbitrator. However, he had appeared for one of the parties in other litigation, and because of that, he has chosen to withdraw himself from the matter. I'm only praying that a substitute arbitrator may be appointed, my lord. Lordship will kindly take up 16 of my application, my lord.
This
Yes, my lord.
I'm of the view that if the section 11 has already been disposed of and he was appointed, his substitution can't be done in under 12, under 11. It has to be done under 15. Move an appropriate application, will substitute. Or you show me the law that I can do it in 11.
No.
I according to me, I can't do it.
Lordship.
If you have any authority to support your contention, you tell me. Otherwise, move an application under 11, under 15. Substitution.
Then Lordship will kindly make it not today, my lord. If I don't find anything, Lordship, I will come back. And then Lordship
Then you move
may
an
ask
application, yes.
necessary
Withdraw
deduction.
this and yes. Then you
Yes,
find
Lordship, kindly makes it not today only, my lord.
not today.
I'm deeply obliged.
I am for the petition in this matter, my lord. I'm praying for extension of some time to effect substituted service.
For the, my lord, the opposite parties, my lord, your lordship, my lord, before that, my lord.
Is here?
Item number 11. No. The service could not be effected on the other side on twice occasions, my lord. Yes. But my lord Justice Sarkar was pleased to, my lord, direct me to effect substituted service within 2 weeks. It could not be done within that time, my lord. I'm only praying for, my lord, extension, my lord.
for some time to effect substituted service, my lord.
Learned counsel for the petitioner seeks and is granted further 2 weeks time to
Lord.
comply with the order dated 26 February 2026.
Kindly makes it 4 weeks, my lord. It will take some time, my lord, to
4
obtain the
weeks
draft
to
and
comply with the order dated 26 February.
grateful, my lord.
Yes.
I beg to appear for the petitioner, lordship.
Yes.
Last day, lordship, you recollect them. Yes. Yes. Lordship, I beg to appear for the petitioner. Last day, lordship, that was the development agreement and lease deed that contains arbitration clause. Your lordship asked me to satisfy you that limitation clause, that development agreement and the lease deed dated that was 2016, and arbitration clause and arbitration notice that was 2026. And your lordship asked me to satisfy your lordship to
Who was on the other side?
no one is appearing in this matter. Kindly lordship take Shompa Sarkar's Honorable Justice Shompa Sarkar's order. There is a time gap between lease deed and arbitration notice. And for such reason, I have also filed supplementary affidavit incorporating all those annexer which I have.
Not today. Next.
Lord, in item 13, my lord, Mr. Shambhu Chakraborty is appearing on behalf of the respondents, my lord.
My
But
lord,
due
I
to
am
some
for the
personal difficulties, my lord, he is not there today. Lordship, I am humbly seeking for an adjournment for the day, my lord.
My lord, my affidavit in reply may be kept in record.
Affidavit in reply filed by the affidavit in reply to the affidavit in opposition. You're for the petitioner, right?
I'm for the petitioner, my lord.
Is taken on record. Filed by the petitioner is taken on record.
Yani, আমাকে adjournment দেয়,
Learned counsel for the respondent, proxy counsel for the respondent states that the main arguing counsel is indisposed, prays for an adjournment. Let this matter be adjourned for 2 weeks, 1 week.
1 week. Whatever my learned senior friend pleases, your lordship. I have no hope.
This is for today only.
For today, that's my instruction is, your lordship. Kindly keeps it next week, your lordship.
21st.
21st. Grateful. 21st.
Give your appearance.
My lord, my lord. Yes. Lord, in item number 14, my lord, I am appearing on behalf of the petitioner. Now, my lord, there was a direction for filing a supplementary affidavit, my lord. We have already filed. Your lordship kindly takes, my lord. The respondents are not appearing even for the last 3 days, my lord. They have not been appearing. Otherwise, service has been made, my lord. This is the affidavit of service, my lord, in respect of the.
What are you seeking?
My lord, for appointment of arbitrator, my lord, this arises out of a development agreement of the year 2007. Now, my lord, thereafter, there was a assignment deed with the respondents, and subsequently, the properties, my lord, halfly constructed, my lord. It's there. Now, my lord, on the last occasion, the coordinate bench was of the opinion
that this is a claim of 2007 that I am seeking before this honorable court. Subsequently, there has to be certain documents which shows that there is the continuous
Continuity.
yes, my lord, continuity of my cause. Now, your lordship, I have in my supplementary affidavit, I have annexed few documents, my lord, that needs to be seen by your lordship once. Now, if my lord kindly allows me to place the section 11 application first. Now, my lord kindly takes your lordship the arbitration clause of the development agreement of 2007.
2007 agreement. When was the project to be completed?
The project was to be completed, my lord, within 30 months from there. Now, my lord, what has happened, your lordship? Thereafter, in
Not even 3 years.
2011,
Yes.
there was an assignment deed. Assignment with the respondent. First, my lord, 2007 development agreement was entered with, my lord, one Devcon, Devcon Private Limited. My lord will find it was entered in 5th December 2007. Subsequently, if your lordship takes the first development agreement once at page number, my lord, 11. This is the first annexure A, my lord. This is the 2007 agreement. Lordship will find the time allocation at page number 26, where it's written, my lord, that 30 months from the date of execution of the agreement, the construction has to be made. Now, subsequently, what has happened, my lord? The property was lying idle. Now, your lordship kindly takes the arbitration clause once your lordship kindly takes at page number 33 of this same development agreement. Page 33, my lord, clause 10 is my arbitration clause. And now your lordship kindly comes to the assignment agreement at page 41 of 12th August 2011 with, my lord, the respondents herein. Now, my lord, there is the dispute is regarding the owner's allocation that the petitioners were supposed to get out of this development agreement, my lord, that has not been given to us. And subsequently, what has happened is the respondents, by virtue of a deed of conveyance, they have sold off the property of the owner's allocation in the year 2022. The property is still lying, your lordship. Now kindly takes, my lord, the supplementary agreement once. I have annexed few documents, my lord, that are of 2017. And as the coordinate bench was pleased to, my lord, direct me to file the supplementary, if your lordship kindly takes the supplementary agreement once, my lord. Affidavit, supplementary affidavit. If my lord is taking section 11 application, my lord will kindly comes to page 95. That is my section 21 notice. No reply against my section 21 notice as of date, my lord. Now, if your lordship kindly takes, my lord, my supplementary agreement, what I have supplementary affidavit, what I have relied upon, my lord, kindly takes, my lord. If your lordship kindly comes to page number 5, this is a deed of conveyance of 2022, where certain portions of my allocation has been sold off to a third party. And after it has been sold off, the proceeds, my lord, the sale proceeds, the shares have not been
21
handed over
notices,
to me.
when did you issue the 21 notice?
My lord, 21 notice, if your lordship takes my section page 95, 31st October 2025.
Tomorrow. Rest of the matters tomorrow.
My lord. I'll come back tomorrow. Great. Huh? Okay, na? Okay. My lord, item number 25 will be disposed of by lordship.
Your grievance has already been solved. Item number 15. Your grievance has already been sorted out, lordship. Let the matter be disposed of.
Item 15.
15 of
What is there?
Let's
What is
section
there?
11. Section 11 petition was there, lordship. In the meantime, lordship, they have already issued the MC to ask lordship what is the dispute in this arbitration clause, lordship.
So you withdraw it.
So, lordship, there is nothing remains, lordship.
Learned item 15.
It is been settled between the parties. That's why it's
Call out 15.
GS को तेरा नाम देता है क्या?
Learned counsel for the petitioner seeks to withdraw the present petition.
It has been amicably
Since
settled
the matter has been amicably settled between the parties, the same is dismissed as withdrawn.
Grateful.